one of them was Alan. That must be me. Sorry, guys. I wonder if I can. I leave it up to you.
Any order the court finds that would better
that is the position that we think is incorrect.
Do you want to rebut that, Mr. DeVore?
Briefly, Judge, if I could.
Thank you, Your Honor.
Thank you.
Judge, while it's not specifically in front of you, I just want to briefly say that you mentioned a potential, even though we don't have one, any IDPH emergency rule that might be promulgated, but has not been regarding vaccination testing, etc. It's not in front of you, but we would still ask the court to consider that if they tried to adopt that rule, there would be a question of whether or not that administrative agency could adopt a rule that conflicts with the law. So, setting that aside, I'll move on. Judge, interestingly enough, the arguments that my colleague just made, there's a huge overlap, and if the court hasn't read it yet, I would ask it to do so. Read the United States Supreme Court's decision that it did on the OSHA.
I read it.
Okay. So a couple of points that I think that you can find an overlap in is that the court there said that OSHA claims this power to issue this mandate or rule, whatever you want to call it, but they can't trace it to any clear delegation of authority. And I would ask you, Judge, that same analysis applies here. The school district is trying to suggest to you, under these general delegations, that includes the ability to create rules, regulations, whatever you mandates about public health. About public health that permeates well outside of the school building. It covers the whole state. And they cited to Justice Marshall from 1825 and said, you know, there are some issues that are so important that they must be regulated by the legislature itself. And there may be less interest, which a general provision can be made and then leave those other bodies of government to fill in the blanks. But they said this mandate's not one of them. That's what they said, Judge. Judge, you can go into the Illinois statutes, and I can cite to you 4 specific statutory provisions that deal with the vaccinations of our citizens, where the legislature has specifically said vaccination is appropriate. You have the Illinois School Code under Section 8.1 that talks about the vaccination. Again, there's an overlap here, Judge, of the K through 12 students. Who did the legislature give the authority to implement that program? Not the Illinois State Board of Education, not the local school boards, the Illinois Department of Public Health. And the Illinois Department of Public Health created the rules under the administrative code. I have it over here. Under Section 665 of Title 77, they lay out all the rules of how children can be vaccinated. And guess what? If you're not vaccinated, you might be excluded from the school, unless you have an exemption. We also have, Judge, the College Student Immunization Act. We have a specific law that says, under 110 ILCS 20, where the Illinois legislature has said, if you're going to be a student in an institution in this state, you have to be vaccinated for certain things. Who did they authorize to create those rules? The Illinois Department of Public Health. Because we have students that come into our state to go to school that didn't go to grade school or high school here, so they're covered too. We also have, Judge, 20 ILCS 2310/2310-650, the influenza vaccination program dealing with the medical profession. Who was given the rulemaking authority to implement that? The Department of Public Health. And people that work in the medical facility can be required to undergo influenza vaccination. Those are 3 specific rules, Judge, that are supported, which is an important thing for you, supported by clear legislative action. Under those specific circumstances, it can be compelled. Now, my colleague says, well, Judge, but we're not requiring vaccination. We're requiring that they have to test if they don't vaccinate. If you read the generic general provisions that they cite to you out of the school code, they talk about the maintenance, the operation, the development of the schools. And they ask you to interpret that to mean that includes public health. Judge, public health. They're asking you to determine that that general rule in the law is so broad that it covers this. And Judge, if you were to accept that, you kind of asked the question with your example, it could cover anything. Anything they want. Now, is there a provision in the law besides the 3 specific provisions of vaccination that I talked to you about? Yeah, the Illinois Department of Public Health Act. It covers every citizen in this state. And it deals with specifically, Judge, specifically vaccination and testing. It could not be more clear. My clients aren't presenting to you some general provision in a code that covers everything under the sun, like OSHA tried to do and they lost. This is specific, Judge, specific provisions. Who did the legislature empower to deal with that? The Illinois Department of Public Health, under Section 690, 1300, and as we continue. And one of the provisions that I think is important, Judge, that the legislature did is it gave them under Section 20 ILCS 2310/2310-15, the legislature, who acknowledges that the general supervision of the health of our people is within the health department, gave them the authority to delegate that to who? Certified local health departments. Nowhere did they say that the health department's power given to them by the people can be delegated to a school. Go to the school, go to the rules and regulations, Judge, under Section 690.1310. I'll go ahead and hit you with one of the balancing arguments here, Judge. I want you to read Title 77, Section 690-1310. This is the provision, Judge, where the Department of Health actually delegated its power given to them by the legislature on issues of vaccination and testing and masking to the certified local health departments. And read this, Judge. Last sentence. Due to the need for immediate action to respond to the threat of a dangerously contagious or infectious disease. Read that again. Due to the need for immediate action to respond to a threat of a dangerously contagious or infectious disease, the Department of Health delegates its powers to issue orders of isolation, quarantine, closure, physical examination and testing, specimens, administration of vaccines to the health departments, certified local health departments. The legislature, who determines what's best of the interests of the people of our state, said that in order to protect people, when we need to protect them from contagious diseases, we give that power to the certified local health department so they can act quickly. Judge Trumper, when she balanced the hardships in her order in 2021 MR 18, which was issued by her on September 1st, she had a whole paragraph on that, Judge. And she put a provision of the law where she cited a 1986 case of People v. Corrigan. You can read it in her opinion. It's well established that the legislatures and not the courts have the primary role in our society in deciding what the interests of public health require and select the measures necessary to secure those interests. Judge, the legislature has decided how to protect the public during times of right now. They decided, and they decided to create this power, give it to the health department, and the health department, with the approval of the legislature, delegated it to the local health departments. Now, Ms. Haggard, and I'll say it over again, I appreciate her candor and honesty, said, well, if we do that, though, the system might break down. Judge, that's not for us to decide. The legislature said that in their opinion, when they were balancing the rights of the people, because the law, as it's written, does potentially, under the right set of facts, impugn the liberty interest of our citizens. It could, but there's a balance that they did and said, these rules, under Section 690.1385 that lays that out, these rules We take those into account, the liberties of the people, the rights of the public health, and we have decided that this is sufficient. And they're going to argue to you, well, if you balance the hardships, Judge, and you give people their due process, which is what they're asking for, we've got our affidavits of the best experts that we could buy that say, oh, this might not work. This system might break down. Judge, not only is that speculative, it's contrary to what the law says is sufficient. So if you're balancing the hardships and you find the other elements are met, it's easy to balance the hardships. Did you see the United States Supreme Court when they entered their ruling? Did they go down that rabbit hole? They didn't. They didn't go down the rabbit hole of the balancing of, 84 million people might, who they were trying to cover. No, they said the law is the law. And they said, if this court were to abide by the law only in tranquil conditions, declarations of emergencies would never end, and the liberties of our constitutional separation of powers would amount to little. So they're going to try the scare tactics on you, Judge, with the balancing of the hardships, It's a real easy response. And in the orders that we have that you may have read from the other 10 courts that granted, again, injunctive relief as it related to masks and also to the exclusion from school, it's a similar analysis. They all said when they balanced the equities, they took into account that we already have significant legal provisions in place that the legislature has deemed sufficient to protect the public's interests. And so balancing was in favor of my clients, Judge. So Jacobson v. Massachusetts, they always like to go to that. I don't think the state does so much anymore, because there's been an appreciation now that in that, when you're dealing with vaccines, who was trying to put those vaccine requirements in place? The legislature. It wasn't the Illinois State Board of Education or some other administrative agency. You can scour the rules, Judge. You can scour everything that you have, and nowhere will you find that we have ever put these kind of public health measures in place under such flimsy circumstances without specific delegation from the legislature. The Illinois School Code, if you go through it, and I know you have, I think there's at least 10 amendments they've made to the school code since the start of this pandemic that deal with when the governor has declared a disaster. None of them put any of what they're asking in place. And if the legislature would have done that, or if you grant my clients relief and the legislature comes back in session and says, we're going to put this in place, I'll walk in this courtroom with a smile on my face and dismiss this case, because that would have been due process. The people would have had their chance to be heard in front of the legislature, and that's how it works. But until then, accept the law as it's written, ma'am. The law as it's written is clear on what it takes to vaccinate or test or mask somebody. The provisions they're trying to give you, these general provisions, again, they're asking you to interpret it and strain it in such a way that the U.S. Supreme Court didn't buy, and I'm asking you not to either. Thank you.
Good morning, Your Honor.
Hello, Ms. Jones, right?
Yes, no, Stephanie Jones on behalf of Waterloo School District 5, Crystal Lake,
Go over that while you're speaking. Thank you.
Waterloo School District 5, Crystal Lake 47, and Arlington Heights 25.
Okay.
I want to talk about some specific provisions in the school code that we haven't mentioned in either hearing yet, and those are really the provisions that give ISB authority.
Okay.
So the Illinois State Board of Education is a constitutional agency. It was established by Article 10 of the Constitution. So it is one of two constitutional agencies, that being the State Board of Education and the State Board of Elections. And it gives the State Board of Education broad authority over education. Okay? It gets more specific than that in the school code, though. The school code in section 2-3.3, so that's 105 ILCS 5/2-3.3, it's one sentence. That provision in the statute is one sentence, and it directs the State Board of Education to supervise all public schools in the state. So that's a very broad provision, supervise. If you continue down through the State Board of Education's obligations, section 2-3.25 talks about what it means to supervise. And section 2-3.25 sets standards for schools.
I'm sorry, tell me that,
2-3.25,
Okay.
so 5/2.
Yep. I was getting confused there, thank you very much.
Yeah. And the first paragraph of that statute says, to determine for all types of schools conducted under this act, efficient and adequate standards for the physical plant, heating, lighting, ventilation, sanitation, safety, equipment and supplies, instruction and teaching, curriculum, library, operation, maintenance, administration, and supervision, and to issue, refuse to issue, or revoke certificates of recognition for schools or school districts pursuant to standards established hereunder. And then to determine and establish efficient and adequate standards for approval of credit for courses given and conducted by schools outside of their regular school term. Now, there are other provisions of the school code that condition both the receipt of state funding and a school district's ability to issue a diploma to a graduating high school student on the granting of recognition by the State Board of Education.
Okay.
So that gives the State Board of Education very broad power over the management of the operations of school districts. From there, the State Board of Education has adopted regulations, and this is 23 Illinois Administrative Code, section 1.20, that talks about operational requirements. And it's very clear that schools and districts are recognized by the state based on compliance with requirements imposed by law, which includes but is not limited to these requirements that it lists out. And this includes health and safety requirements. So this includes that, a school district can be placed on probation if it exhibits deficiencies that present a health hazard or a danger to students or staff. So these words don't limit a health hazard to everything that doesn't, that the Department of Public Health doesn't have authority over. It gives the State Board of Education that authority over a health hazard that faces a school building or a school district. And so I think that is distinguishable in terms of what Mr. DeVore is arguing. I think the State Board of Education has that authority to issue to a school district an order or a direction or a directive with regard to health and safety within a school building. A school building is not a private corporation. And Mr. DeVore is comparing the OSHA standards that were set for private corporations, multi-million-dollar corporations, to standards that are being set by the state against a school district, or the standards that are being adopted by school districts themselves about their own buildings and property. And there's a big difference here. We're not a multi-million-dollar organization. We're not governed by OSHA. We're governed by the Illinois State Board of Education. And if we don't follow the directives of the Illinois State Board of Education, we risk our recognition, which risks for a school district both their state funding and risks their ability to issue diplomas to graduating students.
And I get that, but again, the one thing that I am still questioning is what authority gives that to ISB to do that, to then give it to the schools?
The Constitution. The Illinois Constitution, Article 10 of the Illinois Constitution, empowers the Illinois State Board of Education to manage schools. The Department of Public Health is not established by the Constitution. The Illinois State Board of Education is. It has broad authority to establish a healthy and safe environment in schools. And if I take Mr. DeVore's argument, and his argument's about COVID, but if I take Mr. DeVore's argument and I apply it to pink eye, I want to think about those effects. His argument would apply to pink eye. And if I had a breakout of pink eye in a preschool classroom, which I promise you that my clients probably have right now, because they often have pink eye.
Yeah.
It's a highly contagious infectious disease.
Mm-hmm.
Somebody in one of our schools has pink eye, probably thousands. We send those people home. We require them to be not contagious when they go home. And so we have the ability to make rules associated with that. Let's take lice.
Let me ask you this though, and this is just hypothetical. I think what Mr. DeVore is getting at is, let's use pink eye. School nurse says you have pink eye, you gotta go home, and most parents say okay. What if the parent said no? My kid's staying in school. So then what? What happens? He's saying, then give us due process, and you know the argument.
I mean, it depends on the school district and their policies on how they handle a parent's refusal to pick up a sick child from school.
Okay.
Some school districts have policies or procedures in place that say you don't have a choice. You have to pick them up.
Okay.
And they will sit in the nurse's office, or they will sit in an exclusionary area until you come. And they will not be welcomed back until they, can prove that they're free from pink eye or something along those lines. Some school districts go as far as calling the police and saying, this child is no longer within our responsibility. You need to come pick them up because their parents refuse to. Some school districts will call DCFS over that and complain of neglect. So there's a variety of approaches depending on the school district and their policies and procedures.
Okay.
But that's where, when we talk about, there's all of this, we've talked for days about ISB authority, IDPH authority, school district authority. None of it's mutually exclusive. It's all of this. The way I think about it is almost like it's like layers of pastry. It's not even like stacks of things. It's layers that are layers upon layers upon layers that are delicate. And if one goes away, it doesn't mean that the other one's not ready there for you to take a big bite out of. So I'm not saying that we can do anything under the school code. I'm not saying that the school board's authority is completely blanket and they can order any health and safety requirement that they need to. I think it's pretty close, though, when it comes to health and safety of students. I think it's pretty close when it comes to making sure that our staff members can stand up in front of a classroom and teach kids. I think it's pretty close when we're talking about putting kids on a bus with a highly infectious disease. And so when we're talking about health and safety requirements, I think that's how it filters down. It filters down from the State Board of Education to the school districts with the provisions of the school code that Mr. McCorney so articulately explained to you.
Okay.
The other piece of this is that the State Board of Education also adopted emergency rules. If we go to the testing requirement, the State Board of Education adopted emergency rules. And I'm not getting into whether or not those are appropriate or not. Mr. DeVore and Mr. Verticchio argued that at length when we were here last time.
Yes.
But those rules are in place. And when a State Board of Education adopts emergency rules, and we're under the authority of the State Board of Education, a school district has to abide by those rules. I think we have an obligation to follow the direction of the agency that is constitutionally empowered to govern us. So I don't know how a school board can say, well, they adopted emergency rules, but we don't really feel like there's an emergency, so we're going to ignore it and not do what you're telling us to do. Now, to add to that, ISB has taken the step to put those emergency rules, that's the Part 6 emergency rules, they have taken steps to put those emergency rules into permanent rules. And in fact, at today's ISB board meeting, which is actually happening right now as we speak, I think they have a time period set aside from 2 till 5 p.m. this afternoon. They're holding a public hearing on those emergency rules.
Okay.
And so when we talk about that kind of due process, that kind of due process is there. The regulations that I cited to you in section 1.20 about the State Board of Education being able to remove recognition if a school district exhibits deficiencies that present a health hazard or a danger, those regulations went through JCAR. They're not new. They've been in place for as long as I've been here. So they went through JCAR.
And I have no problem with that. But the emergency rules did not.
They did not, but I'm not talking about the emergency rules right now, right this second. I'm talking about the rules that are in place that give the State Board of Education the ability to put a school or a district on probation if they exhibited a deficiency that presents a health hazard or a danger to students or staff. Now, it doesn't say in those regulations that went through JCAR, it doesn't say that the health hazard has to be identified by IDPH.
Okay.
It doesn't say that. It just says a health hazard or danger to students or staff. So to me, since it doesn't say that IDPH has to identify the health hazard, it gives ISB the ability to interpret what is a health hazard. They have their own experts. They have their own health people. They have a whole division on wellness that can look at the state of a health hazard and say, this is a health hazard. this is how we're going to react, and this is how we're going to supervise our schools. And this is what we're going to direct our schools to do in response to that health hazard. I don't think there's anything in any statute that says that ISB cannot identify a health hazard and tell a school that it needs to comply with certain requirements to make sure that a health hazard is contained. And I would go back to pink eye, or I would go back to lice. I think lice is actually a really good example because you're no longer required to send kids home for lice, believe it or not. And I have to say, I talk about lice and I want to scratch my head, but that's the reality. ISB has monitored that as a health hazard. They have experts that talk about that as being difficult to manage in a classroom and it spreads quickly, but it's not truly a health hazard that's going to infect students and make them ill. And so their recommendation to schools, their direction to schools, is to no longer send students home, but instead send them to the school nurse and have the school nurse work with a family to do what it needs to do to diffuse the lice situation. So ISB has, in certain circumstances, reacted to health hazards, and they've never called, they don't call IDPH when there's a lice breakout. School districts don't call their local health department when there's a lice breakout. They don't call their local health department when there's pink eye. They don't go to court, certainly, to exclude a student that has pink eye that needs to go home. And the other piece about exclusions and due process, right? And we talk about staff members and students in due process and their due process rights. A staff member has a due process right in their wages. They do. They have a due process right in their wages. But that's not what Mr. DeVore is arguing here. He's saying that they have a due process right in the Illinois Public Health Act. You know, he's saying that they have the right to a hearing before they're required to be excluded from school or wear a mask or go home. That due process right doesn't preclude, how do I want to say this? That due process right does not preclude a school district from taking actions. I'm not saying this very clearly.
Take your time.
The Illinois Public Health Act refers to public health orders of a local health department or the Department of Public Health. It does not refer to a school district's actions, to another agency's actions to maintain health and safety that they have the right to maintain. And so when we talk about that due process right, when we talk about the due process rights that employees are afforded, I'm not sure that that's one that a school district is bound by. It does not clearly say in the Public Health Act that the school district is bound by those due process rights that are required of a local health department or a department of the Department of Public Health. I think that's what I'm trying to say there. With respect to the OSHA case, I think the distinction, and I mentioned this once before with respect to the Supreme Court case, is that OSHA was trying to regulate workplaces. And in this case, we have a state board of education that has the authority to regulate workplaces, and we have a school district that has the authority to regulate workplaces that are regulating workplaces. There's a difference there.
All right.
The school district owns that property. So the Supreme Court didn't say, large corporation, you don't have the right to require your staff members to be tested. They didn't say that. They're not saying to Apple or other corporations that are making the decision to test their employees, they're not saying you can't do that.
All right.
The Supreme Court said, OSHA, you can't tell these private corporations that have their own rights with respect to their employees, or that have their own rights with respect to, where their employees have their own rights with respect to employment with their employers, you can't tell them that they have to test. Now, in our case, we're talking about a school district telling its own employees. We're not telling the church down the street that they have to test their employees. We're not a governmental agency telling, we're not telling another governmental agency that they have to test their employees. The school district is telling their own employees that they have to test based on a state mandate that is requiring them to test. Am I making sense with that distinction? At least my argument. You may not agree with it, but am I making sense there?
Yeah. I'm trying to wrap my head around it.
So, but I think that that's the distinction there.
I understand what you're saying with that distinction, but I mean, if we're gonna go back to the OSHA case, the Supreme Court went back to the grant of authority from Congress. That's what they said. Congress did not give OSHA the authority to mandate this. They're not talking about, I think, this broad authority that they specifically went back to the Congress and whether there was a proper delegation of authority.
Okay, well then I would go back to the delegation of authority through the Illinois Constitution to the Illinois State Board of Education to manage schools, the statutory authority to supervise schools, the statutory authority to recognize schools that are free from health hazards, and the regulatory authority that went through a legislative committee in JCAR that says that the State Board of Education has the authority to regulate whether or not a district is meeting health and safety standards in schools. And they have the authority to set those health and safety standards.
Okay.
So I would fall back on that.
Nope, I follow you. I follow you on that.
Okay.
Okay.
I think that covers everything. I wanted to make sure I clarified.
No, that makes sense now. Give Mr. DeBoer a chance and then you can. I like to be able to go back and forth.
Let me clear this up, Judge. First of all, the analysis given about pink eye and things like that and the examples given, Judge, the example they didn't give is that, well, if we have a child that has pink eye in this class, we're going to send the whole class home because we think they might have been a close contact. That's the example. At no point in time has there ever been a suggestion that a child who is exhibiting symptoms of a disease, of any type of infectious disease, can't be excluded from the school. It's absurd. And that was what they were trying, again, to redirect you down that path, which is not the path. I'm kind of glad that my colleague brings up the recognition status through ISB, et cetera, because I think there was some conflating of whether or not the local school district has its inherent discretion or whether ISB has the authority to compel them. It's two different things, and I think they were kind of getting overlapped. And as to the issue of their inherent authority, I'm not going to go back through that again. We've already covered that. They can't cite you to any specific statute. They just try to say, well, the Constitution's new now, but you know, these general provisions of operating the school. Again, this would be the first time that general provision had been interpreted that we can become public health experts and we can start issuing policy of public health. But let's talk about this issue of ISB, Judge, because they cite to you the provision out of the statute 2-3.25, which deals with standards that ISB can promulgate. And those standards then have to be put in place by school districts. And if they don't do that, their recognition status could potentially be implicated. I'm glad that they brought that up. If the court looks at the mandatory vaccination for school personnel, the ISB rule. Now, right now, it's in effect, unless you deem it otherwise, under the emergency provisions.
Okay.
They are, is it interesting enough, Judge? We were able to get, I don't know, about 500, more than 25 people to say we want a public hearing on ISB on the propriety, the substantive propriety of this rule. Not procedurally, their emergency games, set that aside. Whether or not, as a matter of substance, ISB can do this.
Okay.
They set it for a public hearing today, the same day as your hearing. Isn't that a coinky-dink? It's at 2 to 5, so be it. But what I think is interesting, if you look at the authority that they rely upon, that they say gives them authority to create this, they don't put the Illinois Constitution. They don't even put section 2-3.5 where they can promulgate standards. They don't list that. They list 105 ILCS 5/2-3.6, which is a statute I'll talk about in a second. And guess what else they list, Judge? They list the governor's executive order. The governor's executive order, according to them, would give them authority to create rules regardless of whether the legislature has given them the authority to create such rules. You know what I found interesting about the OSHA case analysis, Judge? You know what they didn't do? They didn't do an analysis of whether or not President Biden's executive order directing them to do these things gave them any kind of authority to do it. The United States Supreme Court solely focused on whether or not they have legislatively been giving any of this authority. There was no conversation about whether the executive could cloak them with authority to act as an agency beyond that given to them by the legislature. It's absurd. They didn't do it. I'm sure Mr. Verticchio, I know he already tried to do it, but the court should make short order of that. Again, regardless of how it rules, I hope we can move forward going that a governor can issue an executive order directing an agency to create a rule about something they've never been given authority from the legislature to create. But let's look at the rule that they cite, Judge. And I want you to read it, if you haven't already, 5/2-3.6 of school code. And it is the most general rulemaking provision that they have. To make rules in accordance with the Illinois Administrative Procedures Act, and again, as we sit here today, we've also argued the emergency rule doesn't do that, but let's move on, that are necessary to carry into efficient and uniform effect all laws for establishing and maintaining free schools in the state. Pretty broad, right? For establishing and maintaining free schools. Do we interpret that language to mean that if they can create rules to establish and maintain free schools, that they can create public health policy by rule? They've never done it in the history of the ISB since this was created. There's no rules created. I'm going to get to the one they try to give you in the recognition status. We'll talk about it in a second. There's no rule you'll find anywhere in Title 23 that creates public health requirements. And it also says, Judge, they may not adopt any rules that supersede federal or state law. This mandatory vaccination for school personnel, does it try to supersede the Illinois Department of Public Health Act? I would suggest to you it does. But they, again, cite to you Section 2-3.25 that deals with the adopting of standards by ISB, notwithstanding that the rule doesn't cite that provision. Let's talk about it for a second. This suggestion that ISB can penalize the school district, then, if they don't comply with this masking requirement. That's what they were arguing. Or I guess they would argue with the vaccination for school personnel. If you don't put this policy in place, we're going to put you on probation. And my colleague says, well, what are we to do, Judge? We have an obligation to follow ISB. Judge, that's what's wrong in this state. We have at least got 5 school districts right now out of 824 that have said, wait a second, ISB, do you have the authority to tell us that we have to do this? There's 5 of them. Cowden Herrick, Red Hill, Beecher City, Hudsonville, and Vandalia. Cowden Herrick, Beecher City, Red Hill, Hudsonville, and Vandalia. All 5 of them are saying, wait a second, we have an obligation to follow ISB if what they promulgate is lawful and proper. We don't think what you're doing is. That's the obligation that these school districts have, but no, for whatever reason, they chose to yield. 3 of those school districts are my clients, Judge. I've argued this issue that my colleague just tried to suggest to you as basis for you to deny our relief. And you know what? I've argued it in Effingham County. ISB lost. Another attorney argued it as to a private school. ISB lost. If you read section 1.20 of Title 23, it says that if you are deficient and that causes a public health issue, you may be put on probation. But deficient in what, Judge? Deficient in what? The standards. The standards that have been promulgated in Title 23. Not just deficient on whatever we think. That's what ISB would suggest, and that's what they tried to suggest to Judge DeLong. He wasn't having it. If you, when they cited to you out of the statute where they can create standards for safety, if you go into Title 23, they've in fact done so. There's a whole section, it's under Part 180 of Title 23, and you know what all of it deals with, Judge? The safety of the buildings. Heating, ventilation, plumbing, electricity, on and on and on. All kinds of safety requirements in there. I asked in the affidavit from State Superintendent, what's the deficiency? That my clients are a public health risk. You said they're deficient. What are they deficient in? Sworn affidavit. She didn't know, but I'll move on. But again, Judge, there's nothing about safety in the code or in the rules that deals with anything other than buildings. Nothing about public health. ISB, for the first time ever, is trying to say, well, we're going to compel vaccination on school personnel. There's no provision in the law delegating them the authority to create vaccinations. I gave you all of the laws dealing with vaccinations. Specific legislative enactments say you might have to be vaccinated. You might have to be. Legislature didn't change the school code and say, wait a second, we believe that school personnel need to be vaccinated. So we're going to create a law that says they have to be. And, by the way, we're going to empower the Illinois State Board of Education to create rules to put those policies in place. That's not happened yet. And ISB tries to rely upon a governor's executive order and the generic rulemaking provision about establishing and maintaining a school is authority to create their vaccine policy. It's completely inappropriate, Judge. The suggestion that the standards in Title 23 somehow or another require these school districts to have to follow the vaccine, that's what my colleague's suggesting. Again, there's no authority for that. If you do your own analysis, you can look at there's a TRO in place right now in Effingham County against ISB that says you can't implicate them for this. You know, we were set for preliminary injunction on January 12th in that case, Judge. We got the TRO, it was set for January 12th to have an injunction hearing. ISB asked for it to be continued until like April. If it was really such a public health emergency, Judge started laughing. Well, we're going to wait till April? Yeah, their request. Judge, ISB can't force these rules on these school districts. The school districts can't rely upon this ISB rule. The one in front of you today is still an emergency rule because they're going through the public process to try to at least deal with the procedural problems that the rule in front of you has. But that's not for you today. We still proffer to you that that rule is invalid procedurally because there was no emergency. And we also proffer to you that substantively, if you look at the authority they try to rely upon as the basis for creating this vaccine, that there is no legislative authority that has specifically and clearly, as the United States Supreme Court did in the OSHA analysis, specifically and clearly empowered them to create such an overwhelming rule. Thank you.
Your Honor, if I may briefly respond to, Mr. DeVore's raised the Supreme Court's recent OSHA case. Mm-hmm. And I think this is a matter of importance because he's suggesting that there's some parallel here that the court needs to pay attention to. I just very briefly like to direct the court's attention to Justice Gorsuch's concurring opinion in that case. Okay. Justice Gorsuch says, there's no question that state and local authorities possess considerable power to regulate public health. They enjoy, quote, the general power of governing, unquote, including all sovereign powers envisioned by the Constitution and not specifically vested in the federal government. And then he cites a number of authorities. And then he explains the federal government's powers are not general but limited and divided. So we have a very different situation here. The Occupational Safety and Health Administration has only those specific powers that are delegated to it by the Congress under the Occupational Safety and Health Act, and it has to adopt regulations within those standards.
Sure.
That was the basis for the Supreme Court's decision in the case that counsel has referred to. What we have here is a situation in which the state has delegated that general power of governing to the school boards. This is the point that we're trying to make in referencing the section 10-20 and section 3418 of the school code. Again, the
Tell me
general...
that section one more time, please.
So it's 10-20, 105 ILCS 5/10-20.
Oh, just that one, okay.
And then it's also 105 ILCS 5/3418.
Okay, thank you.
So these are the provisions that essentially says, look, school boards have this general power of governing, not over the whole state, not over, a given municipality, but within the schools, the school boards have this general power of governing that even Justice Gorsuch acknowledges in the Supreme Court opinion applies to the state and local governments in a way it does not to the federal government. That's the argument that we're trying to make here. And Mr. DeVore's burden, what he has to present to the court, is that there is some provision of state law that expressly says, no, school boards, even though you have the general power of governing within your school districts, this specific power is foreclosed to you. I submit to you, Your Honor, that the plaintiffs have not made that showing. And again, we don't have to go back over the ground that we've covered under the Department of Public Health Act. Of course, the Department of Public Health has the authority to issue quarantine and isolation orders, but within the schools, it's the school boards that have that power of general governing. That's the point that we're trying to make to you, Your Honor.
All right, let me ask you this then. If ISB has independent constitutional authority to do what it wants, then why did they issue a joint guidance with the Illinois Department of Public Health?
I can't speak to why ISB has that authority. I mean, again, one of the things that the school code says is that, broadly speaking, in a number of areas, school boards have to follow ISB guidance, right? So to the extent that there's a provision of the school code that constrains school board authority and says you have to do what ISB says, of course, school boards have to do that. As to why ISB adopted the guidance that they did, or that would be a question for Mr. Verticchio, Your Honor.
Take note of that, Mr. Verticchio.
I just wrote it down, Jay.
Why didn't
Can we talk
ISB
about that tomorrow?
It might be. Yeah, why didn't ISB implement its own emergency rules independent of the governor's executive order? If that's what I wanted. You wrote it down.
Yes,
You
Your
can
Honor,
address it.
and I can't speak to why the state did or didn't do what it, but in the absence of a state order, the General Assembly has said, local school boards, you are in effect the legislature. You are the legislature within your school districts, and you exercise these powers of general governing to, in this case, we're talking about rules that apply to employees acting as employees of school districts.
Okay.
So, it's very clear that the school districts have the authority to set those rules for their employees.
Anything new, Mr. DeVore or Ken?
No, most of what he says, Judge, about what Justice Gorsuch says is true, but the overarching analysis is still the same that the Supreme Court did. If you're an agency, ISB, IDPH, or you're the school districts, and you're trying to say you have this inherent authority, point us to an express provision somewhere that gives it to you, okay? I've pointed to you an express provision of the supreme authority over public health that says the Department of Health may do these things, specifically what we're talking about. I've pointed you to that, saying that that's the controlling law. I'm saying that they are trying to say, well, that doesn't apply to us because we can govern these in our schools because of this generic provision. I believe the OSHA analysis defeats what they're saying is because they should be able to point to something that says this gives us that power. And I think also it was worth pointing out in the OSHA case that no time in history had those agencies, and I would suggest to you these school districts, ever tried to use that language in such a broad, encompassing way that they can create public health policy like they're trying to do. That's all. Thank you.
Good morning, Your Honor.
Finally, yes.
Abigail Rogers, appearing on behalf of Belvedere District 100.
I'm sorry, can you say your name one more time?
Abigail Rogers.
Abigail Rogers, thank you very much.
To the extent your question, your original question about language in the school code,
Yes.
questioned whether there was language in the school code addressing the authority of school boards as employers vis-a-vis their employees. And in light of your reference to the stack of papers in your office,
Thank you
I
very
would not
much.
want you to overlook the reference to 105 ILCS 5/24-5, which expressly gives school boards the authority to subject teachers or employees generally to health examinations.
Yeah, we talked about this before, but go ahead.
Okay, and I apologize, I was not in court
No,
last time.
That's
so-
why I'm telling you that, but yes.
This provision, I think this is well beyond the scope of what we need to get into on a temporary restraining order, but this provision dates back to 1961. Since that point in time, there have been numerous laws enacted that address the relationship between employers and employees, including specifically the boundaries of employers with respect to employees' health matters, such as the Americans with Disabilities Act, which is followed in large part by, within our state, through the Illinois Human Rights Act. Again, this is far beyond the scope of what we need to do, but subsequent legislation is very consistent in interpreting employers to have the authority to require employees to produce fitness for duty documentation and to exclude employees who present a direct threat to the health and safety of others in the workplace. So I would just request that you also consider the specific authority that already exists for employers in this area.
Okay. Okay, I noted that. Any response to that, Mr. DeVore, or?
No, Judge.
Okay, sorry, go ahead, Counsel.
Good morning, Your
Mr.
Honor.
Swain, excuse me, sir.
Excuse me. Of course.
Okay, go ahead.
Good morning, Your Honor. Robert Swain for Districts 25, 5, and 47.
Okay.
And I'd like to address just one or two of these points quickly, and I think I can answer one or two of your questions.
Wonderful.
Yeah. Mr. DeVore has discussed this OSHA case, but of course the companion case that went to the Supreme Court concerned rules from the Department of Health and Human Services, HHS. And of course the result was the opposite. And I think there's actually a good parallel here. At the risk of confusing some of the staff and student issues, and we'll address those tomorrow, but of course we're also kind of understanding these are part of the same ball of wax.
Right.
The Health and Human Service Act, of course, that case in the Supreme Court, those regulations were upheld. The Supreme Court said, the reason why the Department of Health and Human Services has authority to adopt a vaccine mandate, and again, we don't have an actual mandate here, certainly not from school boards. And I want to speak specifically to local school board authority. The reason why the HHS could require vaccine of healthcare workers was because those healthcare workers were responsible for the health and well-being of Medicaid and Medicare patients whom they were serving. That is an important analogy to schools. School
Okay.
teachers, school staff, they're not line workers, we're not in a factory, we're not in a retail setting, okay? Our teachers and staff are responsible for supervising school children. And those school children are compelled to attend school. And the staff are actually responsible for the well-being of those children while they're under the school roof. And we even have, of course, say, school nurses who specifically address, say, some health issues in schools. But my point is that teachers and staff are responsible to try to keep students healthy while they're in their schools. And if we have contagious staff, and again, understanding that none of these mitigation measures are perfect, that's why they're called mitigation, not prevention, right? But if we have contagious staff spreading contagious disease to our students in our building, then we are violating that fundamental principle that we are responsible for the well-being of the students who are in our care. And so actually the much closer analogy here is to the HHS case in the Supreme Court, where there's actually a very good public policy reason to consider there should be requirements for school staff here, different than, say, other employees of other industries. Now, in a similar vein, Mr. DeVos characterized school rules repeatedly as matters of public health. And I think I probably speak for all of my colleagues, both here today and who will be here tomorrow. I don't think any of our clients have ever asserted the authority to control public health. The Department of Public Health does that, okay, among the public. Our jurisdiction ends at the end of campus, ends at the schoolhouse door. And in fact, part of the reason why it's so important for local schools to be able to manage chronic and infectious diseases in their buildings is because we can't control students when they go home at night. We can't control staff when they go out into the community. We have to expect that they're all coming back into the building, bringing with them whatever they may have been exposed to since the last time they were at school. And so when we are compelling those kids to come into the building and employing those staff to be responsible for their well-being, it's incumbent upon the local school districts to do everything they can to protect them from exposing one another to whatever it is they may be bringing from the outside, which is the domain of the Department of Public Health. Now, you asked specifically about joint guidance from ISB and IDPH. If you look at section 10-21.11 of the school code, so that's 105 ILCS 5/10-21.11.
Got it right here.
It says a couple of things. It says, number one, this is in a section of the school code that pertains to powers and authority of school boards. Okay? That the local school board is to adopt policies for managing chronic and infectious diseases, not inconsistent with guidelines from the State Board of Education and the Department of Public Health. So those joint guidelines coming from ISB and IDPH are fulfilling that statutory obligation to provide guidelines within which schools then adopt their own local policies.
But then, this goes back to, this could be from the other case.
Sure.
Because they're all well together. Where I talked about, remember, I told you I found the 2003 joint guidance.
Yes.
And that said how due process, which I didn't bring that with me today, was so important. And then it got amended in August, I believe, and then again in September. So, I don't know where my question is, but
There have been, sure.
why was it amended? And maybe this is Mr. DeVore again.
Your
Why
Honor,
was
please,
all that
Your Honor,
amended?
Your Honor,
Particular, right?
I'm sorry.
Please.
I'm sorry, Mr. Reticchio.
He has received,
Tom's dying over there.
I looked right at you.
Thank you.
he's received enough compliments today. He doesn't need.
So go ahead.
He's not used to getting such compliments.
There have been numbers of these guidances over the years.
Okay.
And they address different health emergencies that evolve and occur over the years.
Okay.
Okay? In 2003, there were a couple specific considerations, I think, and I know some of my colleagues here in the room can even speak to this more specifically and better than I can. But in 2003, there was particular concern about spreads of HIV among
Okay.
especially high school students,
All right.
and implications that it had for treating and categorizing, perhaps a better word, students who were HIV positive as requiring special education services.
Okay.
So if you recall, there were terms in that guidance that you mentioned when we were here a couple of weeks ago, such as least restrictive environment and free appropriate public education. LRE and FAPE are actually special education concepts
Okay.
that arise under the Individuals with Disabilities Education Act, which is a federal law, arise under Article 14 of the school code in terms of triggering different rights for those students in terms of individualized education plans, okay, to address their needs and so forth.
Okay.
So the 2003 guidance was speaking to, here's how schools should be handling and managing students who might be HIV positive
Okay.
within their populations.
All right. Thank you. All right, anything else on the section 10.21-11? Because I think I cut you off.
No, but I think, Judge, the points were yes.
Okay.
One, the local school boards are to develop policies to manage chronic and infectious diseases, such as mitigation measures. Okay? And that, yes, ISB and IDPH have that statutory directive, providing guidelines within which those policies are being adopted locally by school boards.
Just a second. I'm looking at minutes here. I think my note here, though, is more for tomorrow and not for today, so,
Sure. I'll be here tomorrow, Judge.
yes, I figured as much. Okay,
Thank you.
you're welcome. Mr. DeVore?
Just, it continues to go around and around in circles. Well, what about this provision? What about that provision? And I genuinely look for one of them to say, okay, that gives them authority to create their vaccination mandates, exclusion, masks, etc. But I'm reading 10-21.11. To develop policies and adopt rules relating to the appropriate manner of managing children with chronic infectious diseases. Now, what's interesting is my colleagues say, well, we've got this authority, we can do all this stuff. Inherently, this specific provision here would contradict their proposition that they have this general authority, because if they had this general all-encompassing authority, why does the legislature on occasion go through and grant these specific provisions? It'd be a waste of their time. But this particular provision still cuts against them, because it's talking about creating policies and rules for children who actually have a chronic infectious disease. Now again, it's kind of for tomorrow. We're not talking about children with chronic infectious diseases. We're not talking about staff with chronic infectious disease. We're not talking about anybody with anything. We're talking about perfectly healthy people who are being put through these things, Judge. So that provision doesn't have anything to do with anything. It actually stands for the proposition that the school boards don't have this all-encompassing inherent authority. Mr. Swain talked about the CMA's case. I like the case, because the Supreme Court, again, it's 5-4, so be it. They actually said, no, we're going to let this rule go forward. Hopefully the courts read that decision. Why did they do that? Because they found specific language within certain provisions of statutes, and the practices of CMS had long been to put these types of things in place. So you had Chief Justice Roberts and Justice Kavanaugh who made different decisions than they did in the OSHA case. And their basis was, we can find within the law where this has been delegated to this agency. That's the whole conversation, Judge. Can you find within the law? Can you find it? Where ISB, where the governor, where the school districts have been given authority to put these policies in place? Yes or no? We're suggesting to you it doesn't exist. They're suggesting to you, well, you can find it in these obscure general provisions. And what I'm saying to you, ma'am, is that this issue is important enough that if legislature intended to do that, it would be a specific provision, like it was in every other example I gave you where we forced these kind of provisions on citizens. The only thing left is under the Department of Public Health Act. They're trying to suggest to you it doesn't apply. They can provide you no authority for that other than, well, we've got this general provisions. We can make the rules for the operation and maintenance and development of our school. It doesn't get them there. Thank you.
Thanks. counsel, can you give me your name again, please?
Jennifer Smith for Plainfield, Oswego, and Masuda.
Okay, thank you.
So I wanted to follow up on both what Ms. Jones and then also the question that you had about the 2003 guidance and the impact on students with disabilities. It also answers in some part, I think, Mr. DeVore's question about authority and the harm that we're talking about here today.
Okay.
And that is when we get down to an individual, we've talked about the state, we've talked about the school district, but when we talk about individual students, school districts unquestionably have the authority under the Individuals with Disabilities Education Act, Article 14 of the School Code, and regulations, and then also other requirements under ADA Section 504 to accommodate the disability-related needs and health-related needs of students with disabilities. And this extends into areas of health, without question. School districts have to provide nursing services. They have to provide accommodations and a setting that allows students with disabilities to enter. And a lot of my clients, when hearing about these hearings, one of their first questions and concerns was, if you walk out of court and tell me I can't require teachers to mask, and I can't require teachers to test, I have students that can't attend tomorrow because their needs require staff, require a setting that is a certain level of safety. And that permeates, it's not just one classroom. We integrate, we take all needs and we say, when you asked before about that guidance, what it means least restrictive environment, that means we make our schools available to students with disabilities to the greatest extent as if they didn't have that disabilities. And that may inconvenience someone without a disability. So to Mr. DeVore keeps talking about, these are impositions on those who aren't sick or who don't have the disease. Yeah, that's right. To support the needs sometimes of students with disabilities, others have to do certain things.
Okay.
They might have to wear a mask. They might have to distance. We might give greater resources and funding to certain programs so that they can access them. That is in our absolute authority, statutory authority under these provisions. So again, I think it goes to all these provisions. Can you point to? Yeah, I can point exactly to the federal law, the state implementing law, and the regulations that say I have to accommodate the needs of individuals with disabilities, including students, and that might mean I need the authority to require their teacher to wear a mask.
Okay.
And so that should not be removed. That is the status quo, and that should not be ripped away in a temporary restraining order. That would be an inappropriate use. So going to your question about that, the 2003, and we can talk about this tomorrow, but that 2003 guidance and due process under that's talked about in that discussion, not the due process Mr. DeVore is talking about and seeking to enforce, but it is somewhat relevant here. Because if students needed to not wear a mask in school, we have a process for that. If it was based on, he's put in an affidavit from a health expert saying there's health impacts. If there's a health harm, if there's a medical need to not wear a mask, we have a process for that, and we have due process around, you don't like our answer, you can file a due process complaint. Only after you've exhausted that process do you come to court. And they have not done that. That's in our affidavit that we submitted on behalf of Plainfield.
Okay.
Unless there's any questions on that, that's what I wanted to address, Your Honor.
Just a second, I'm making a note so I remember to look at something. Okay. No, go ahead, Mr. DeVore.
Judge, just briefly, I believe this might have been brought up before, but I think the proposition that is being made primarily is that if someone doesn't want to wear a mask because of our policy, well, we have a whole process you can go through to get an exemption. And I kind of chuckle going, we've jumped over the whole purpose of this case, which is that whether or not you can even require it in the first place as part of your policy is what we're litigating. And my colleague just wants to jump right past that and go, well, we require it. If you don't like it, we give you a way to object. We created our own internal policy. Judge, that's not the question in front of you. The question in front of you is whether, and I keep reading it again, if we're going to have vaccinations, testing, treatments, devices intended to limit the spread, again, you have the emergency rule issue you're talking about, in order to prevent the probable, that's an important word, the probable spread of a contagious disease, this is how it has to work. The legislature created that. And my colleague wants to suggest to you, well, we're going to just disregard all of that, and we put our own process in place that people can exercise. They don't get to supplant what the legislature's created because they think it's the right thing to do. They don't get to do that, Judge. Thank you. Here he comes. I'm waiting for you.
Mr. Feeney, right?
Good morning, Your Honor.
All right.
Luke Feeney, Decatur Public Schools. I'll be very brief. I concur with everything my colleagues have said, but I think there's an alternate and perhaps narrower way to view this case as well.
Okay.
Unlike the cases we'll take up tomorrow, this is a case involving employees and their employer.
Right.
In this case, we're not talking about students, we're talking about the school district as an employer.
Mm-hmm.
So first, the school districts are currently requiring testing and requiring masks in compliance with the executive order.
Right.
So the court only needs to reach a decision on the school cases if the executive order does not stand. If the executive order stands, we all continue to follow it. If the court only needs to reach the questions that we're addressing on behalf of the school district if the executive order is not there. And then, in this case, we have 20 different school districts that range in size from Chicago Public Schools, which is the largest school district in the state, to much smaller districts. It's obvious that if there were not a state mandate, districts would make different decisions. Some districts would likely comply with what is currently the mandate. Some districts would come up with unique and individual solutions. As my colleague said, districts could choose to be stricter than the mandate if they want to. Mr. DeVore's proposition, though, is based solely upon statutory authority. And what that would mean, it would not apply just to school districts. It would mean that no employer in the state could require testing or could require masks. Again, we have two TROs in this case, one involving testing and one involving masks. And we've largely glossed the mask issue, but that's on the table as well. The narrow employer-employee relationship, an employer can require an employee to take it, and an employer can require an employee to wear a mask.
True. So why haven't they done that in the past? Why now?
Because they haven't needed to in the past. They haven't. Currently, they're doing it in compliance with the executive order. And again, Mr. Berticchio can address those points. But if that executive order is not present, the schools absolutely, as any other employer does, have the right to require an employee to take a test or require an employee to wear a mask. And we're dealing with public sector employees. Public education is perhaps the most unionized sector that I can think of. These employees have a recourse if they don't like that term and condition of employment, and that's at the bargaining table. I don't believe in any of the districts that are before you today there's been any sort of grievance filed by any of the unions that represent any of the employees in these cases. So, thank you.
Really? Not one single grievance anywhere?
I don't believe, I can speak for Decatur.
Right.
My colleagues can speak for their districts. I'm not aware of a grievance that have been filed against any of the defendant employers in this case over the testing requirement or over the mask requirement.
Okay. I think you were gonna.
I can just add, Your Honor, as far as the Chicago Public Schools, there are certainly disputes between the Chicago Teachers Union and the Chicago Board of Education, but they're not asking for anybody to lift mask mandates or testing. They're asking for more precautions. So, from that standpoint, no, they have not asked for the relief that's being
requested in this case.
Go ahead.
Fortunately, Judge, we're not in a political conversation. Thank goodness. This is a court of law. And I wouldn't pretend to want to get into the political conversation about teachers' unions across this state and how they might allegedly acting in concert with state agencies. So we don't need to even have that conversation. What Mr. Feeney says is I disagree with him. Private employers and these public bodies are not similarly situated. Public bodies have those powers delegated to them by the legislature. Private businesses don't sit in that situation. So to suggest that there's an exact parallel between private employers and public bodies is again, inaccurate. To that extent, we did get a TRO in Adams County against 2 private employers. We argued that masking and vaccination was inappropriate and they shouldn't be, what's the term, Judge? They don't call it firing now. They call it voluntarily terminated. I think that's what they call it. Go home, don't, like Mr. Verticchio said the other day, go home and don't come back until you want to comply. That's not firing them though. But anyway, there's an injunction in that case that said you can't do that. We argued Illinois Department of Public Health Act, etc., healthcare right of conscience. It's in front of Judge Asher now. But again, I would just suggest to you private employers and public bodies aren't the same. But Mr. Feeney is correct. You have large schools, you have small schools. The court has to decide a few things. One is, can the governor, with his executive order, compel school districts to have to put these mandates in place? Can the governor, through an executive order, and I think Mr. Verticchio's talked about it, if not he will again, can he utilize his authority to say, school district, I don't care what the law says. I don't care what the legislature may have given you the ability to do or not do. Do it, and you have to listen to me. We've argued that's not sufficient basis. Mr. Feeney is correct, though, that if you say no, the governor can do that irrespective of what the law says, then their inherent authority or lack thereof becomes really a secondary conversation. The court also has to look at the ISB rules, etc., and say, can any of these state actions force that school district to do something that they may not otherwise do on their own? You have to analyze that. And if you get through all of that and say the governor, ISB, IDPH, none of you can force this school district to implement a vaccination or testing policy, and you can't force masks on people without them getting due process under the Department of Public Health. If you get to that, then you also have to look at also their inherent authority. Do they have this inherent authority? It's possible, I guess, you could conclude that the state can't do any of this, but they have this, these local districts have this unique inherent power to create these policies that they've never created before. They can't point to any specific authority in the law that gives them that. Could you do that? I guess you could. We're saying that you shouldn't, right? But to that extent, I wanted to say that Mr. Feeney is correct. You know, when the court's doing its analysis, if it doesn't make it past the state agency's ability to compel and say, yeah, they can do it, then the inherent authority would not be a necessary analysis. Thank you.
Okay. Are we ready to break for lunch?
Yes.
Your Honor, I just had a few comments to what was said over the last few hours,
Okay.
specific to the vaccine issue.
All right.
Other than that, tomorrow is the appropriate platform, but there were a few
Well,
things
let's
said.
do that, then
on
let's
vaccine.
break, and then we can take up the class certification thing after lunch, if that's all right. Okay. Go ahead, Mr. Particular.
The point has been made, but it is worth repeating, Your Honor. There is no vaccine mandate. There is no vaccine requirement. The requirement is testing. And the court acknowledged that this morning. You nodded. You said, yes, it's testing. It's not a required vaccine. And yet, a few minutes later, the court referred to the vaccine requirement.
I did.
But it's completely understandable, because Mr. DeVore stands up here on and off now for the last 2 hours talking about a vaccine requirement. So it's pretty understandable why people get confused. He marched you through vaccination statutes, telling you here the legislature gave authority to vaccine and the vaccine. It's not relevant. And I'm just implore upon the court. None of that is relevant. There is no vaccine requirement. On the Supreme Court's decisions, the United States Supreme Court's decisions last week, we heard briefly about two of them, the OSHA one and the Health and Human Services decision, issued the same day, January 13th. OSHA required vaccine testing all employees or employers over 100 that had employees over 100 people.
Right.
And the Supreme Court said, you went too far. You went too far. It's not narrowly tailored. It's not specific to any given industry. It's too far, and struck it down. But as Mr. Swain explained to you, the more relevant of the two decisions for today's purposes is the Health and Human Service decision, where the court looked at the situation and did just the opposite. They looked at the vaccine requirement, and there it was a vaccine requirement, and said it's narrowly tailored to health care, and we're going to uphold it. That case is much more parallel to what we're talking about today in terms of testing in schools, where the public health issue is at its zenith with our youth, our preschool through 12. That is a much more on-point and parallel decision. And what I find most interesting about that case is Mr. DeVore's attempt to distinguish it. Because he recognized, he has to recognize that the Supreme Court said that for healthcare facilities, the vaccines are going to stand. And Mr. DeVore said, I wrote it down. I won't do it justice, but I wrote it down. You won't. They found specific provisions in statutes. No, they didn't. It's easy to stand up here and say something like that, but it's simply not true. The Supreme Court in the HHS case relied upon a statutory delegation to Health and Human Services to make decisions in the, quote, interest of health and safety, close quote. That's about as broad and as general as you can get, and it certainly parallels with the authority given school districts by the school code, the interests of health and safety. Mr. DeVore calls that, and again, I wrote it down, quote, an obscure general provision, close quote. He refers to the school code, obscure general provision. Show me something specific. The Supreme Court of the United States on January 13 said a statutory delegation to have concern over the, quote, interests of health and safety, close quote, is an appropriate delegation of authority that specifically allowed for vaccine mandates of millions of healthcare workers. It's a short opinion, Your Honor. That particular portion is on page 5. And here's what the court said about the healthcare vaccine mandate, because it recognized that it's pretty serious. It's out there. Here's what the court said at page 7 of the per curiam opinion. Quote, of course, the vaccine mandate goes further than what the Secretary has done in the past to implement infection control, period. But he has never had to address an infection problem of this scale and scope before, period, close quote. And that is this case. You just asked, with regard to when you were talking to Mr. Feeney, why masks? Why tests? Why now? Why now? Well, 29,000 dead people in this state, 2.5 million cases of COVID. That's why not. And the last point, Your Honor, you asked early on this morning, why only the unvaccinated? Why are they the only ones that are tested? The court can only be guided by the record here. This is a TRO proceeding, a written record. And the only record on that issue is by public health experts submitted by the state parties and the school districts, specifically the Chicago School District. Dr. Bleasdale's declaration, paragraph 20, addresses this exact point. Unvaccinated people are 8 times more likely to contract the virus. These are public health experts, and it is the only record before you on this issue. And Mr. DeVore says that never before have such measures been taken, testing and masks, on such, quote, flimsy circumstances, close quote. Again, flimsy circumstances. 29,000, 2.5 million. Thank you, Judge.
See, my esteemed colleague judge always, he accuses me of it, but likes to leave those provisions out that matter. I didn't try to distinguish the CMS case. The analysis actually works because the decision of the court was twofold. Not only did they find the statutory requirements, I'm going to read to you from page 3. Relying on these authorities, the Secretary has established long lists of detailed conditions with which facilities must comply to be eligible to receive funds. Such conditions have long, L-O-N-G, included a requirement that certain providers maintain and enforce an infection prevention and control program designed to help prevent the development and transmission of communicable diseases and infections. So not only did in the CMS case did they find there was some statutory language, they had found that there was a long history of which that agency had utilized that language uncontested to put these prevention programs in place. You don't have that here. You have these general vague provisions that have never been used by any of them to create what they're trying to create. It's never happened. And the Supreme Court in their decision in the CMS case said not only do we have some provisions that we believe apply, we have a long history of it being used the way that they're trying to use it right now, even though on a bigger scale, they acknowledge, as Mr. Berticchio said, but there was history, Judge, that they had been doing that. No vaccine mandate. Talk about vaccine mandate. Judge, there is a vaccine mandate, but if you don't want to be vaccinated, you can submit yourself to testing. Talking about semantics, of course, either side of this conversation. Is there a vaccine mandate? It says you have to be vaccinated. If you don't want to be, submit to the testing. It doesn't matter, Judge. If you go into the law, vaccination and testing are both covered under the provisions of the Department of Health Act. If the purpose of what they're asking you to do is to try to prevent the probable spread of a dangerous disease. Perfectly healthy people, Judge, no symptoms. We're going to force you to vaccinate or test to try to prevent the probable spread of a disease. That's specifically on point in the statute. They try to point you not only to vague provisions, they try to point you to vague provisions that have never been used in that way before, ever. And again, this whole issue, they talk about Dr. I think Bleasdale, I think her name is, her affidavits have been in front of you for a couple years now. And obviously she works for the state. But Judge, I drug them down that rabbit hole. We'll get into more of this tomorrow when I submitted to Dr. Stock for you just to appreciate there's a competing conversation. They could give you 100 affidavits. People could give you another. That's not even the conversation here, right? It's not even the conversation
of what might happen. When we get back to the balancing of the hardships, which they try to say, oh, doctor says that all this is going to happen. Judge, the legislature, and I read it to you from Judge Tromper's opinion on September 1st, the legislature balances those interests. And they balanced them when they created the laws that we're asking you to enforce. They determined that when we're dealing with a dangerous, contagious, or infectious disease, that these provisions balance the public's interests. And what we're asking you to do is to not abandon and just let there be this free-for-all. That's what they all want you to think. We're just saying, apply the laws that was created by the people that created it that believed that balanced the interests of people. It's still happening in our state, Judge. I'll talk to you more about it tomorrow. I've given you, and you've seen the copy of the order from earlier or late last year, where in this courthouse, the law worked as it was intended. In front of Judge Gigante, states Gigante, I apologize. I always wonder how to say that. He signed the order on modified quarantine, requested by the Sangamon County Health Department, prosecuted by State's Attorney Wright, entered an order that says you can't leave your house, you can't gotta have a mask on, you can't go back to school until this happens. Worked perfectly. Last week, I was in the Christian County Courthouse dealing with the same thing. Christian County Health Department tried to keep the kid out of school because that school had decided, you need a court order if you don't want the kid to come into our school. We went to court. They pled. We're going to keep you out of school, masks, etc. Judge dismissed the case for it wasn't accurately pled. The procedure, I was elated. I'm like, that's how it's supposed to work.
Your Honor.
She said, no.
You know, I'm
of course
sorry.
you don't.
I'm sorry. But if we're going to be talking about, you know, in Christian County, in Effingham County, then we need case numbers. We
I'm
need
arguing.
There's no basis in the record for the argument. There has to be something called a basis in the record in order to make an argument. Could you possibly find that Christian County case if you wanted to? No, of course not. Why are we talking about it? It's inappropriate. It's wrong.
I'll move on, Judge.
Okay, thank you.
Judge, the vaccination policy that they're trying to invoke. Specific statutory provisions in the law. It says, if this is our goal, this is people's rights. They're trying to say, well, they don't have to vaccinate, you just have to test. There's a law that says you can't force somebody to test. They can refuse. They might be subject to isolation or quarantine, but they can refuse. They're trying to say, well, yeah, they can refuse in our school if you want them to, but you're going to go home and be, again, put whatever term you want on it, involuntarily terminated forever. And that's okay because of some general provision in some statute that doesn't remotely address the specific issues of vaccination or testing. They're asking you to completely disregard the provisions that we've cited. Mr. Verticchio, the last time we argued this, says, well, Judge, we've got that, but we've got these lanes. I kind of chuckled when I heard it, but we've got these lanes. And this lane here says the governor can issue his executive orders and tell these other units of government and these other agencies to do whatever he thinks. And that lane is what we're talking about. We're not talking about this lane. I have never heard that analysis in my life. Ever. And you never heard that in the United States Supreme Court. You didn't hear them saying, well, President Biden, he's got this lane, and he empowered OSHA and CMS to do these things. He didn't go down that road, and I'm asking you not to go down that in our state. Thank you.
I have one more question, and I can either ask it after lunch or open up the floodgates now. Why don't we'll break for lunch, and I'll start with this question right after lunch, which hopefully won't take that long. But every time we say that, it always does.
Can we leave this stuff here, ma'am?
Yes.
Thank you.
So let's, we'll aim to start around 1:30, okay? And we'll take up the question I have, and then if, hopefully, we can then move on to the class certification, okay?
Your Honor, may I just make a record? I'm Loretta Haggard for the interveners. I'm confident you're going to rule the same way about my ability to present on the motion for class certification, but it might affect whether I stick around. So I request to be heard on that motion.
On the class certification?
Yes.
as an intervener,
Yes.
I'm gonna deny your request because I haven't ruled on that motion yet.
Thank you.
Mr. Feeney?
Your Honor, if you might pose the question now, we could probably answer it more
Okay.
efficiently after lunch if we chat a little bit.
Mr. Feeney and I are having lunch, we're gonna talk about it.
Well, my question
Not if
is,
he and I chat about it, Your Honor. If my colleagues and I chat about it.
it might
We'll get lunch
require,
some other time, Mr. DeVore.
All right, buddy.
so I believe, and I will have to look at my notes, but I believe the Illinois Department of Public Health emergency rule vaccine mandate, I think it has an exemption for religious and medical.
Which rule are you talking about, Judge?
IDPH is emergency rule that has, it's not the vaccine mandate for healthcare workers. Sorry, I didn't put for healthcare workers. I think it has a religious medical exemption provision to it. Correct me if I'm wrong, but I'm pretty sure it does. Whereas ISB's emergency rules, I don't believe has that same thing. Their basic, and this is where you can correct me if I'm wrong. ISB's emergency vaccine requirement is either you do it or you get fired. You do it, you test. If you don't test, then you get fired. So, am I thinking that correctly, or am I incorrect on that? And if so, that's what I want to discuss. I have to look it up too, but that's what popped into my head. I know for the healthcare workers, there's an exemption. I don't believe there's the same thing for teachers. Either you test, or you can't come in our building, or you get fired. But again, correct me if I'm wrong. That's what I want to talk about when we get back. Unless you can answer it in 1 minute.
I think I can answer it in 1 minute.
You're wrong. Mr. Feeney can't, nor me.
I mean,
Go ahead right now, and then we'll address everyone else after lunch.
ISB's rule says that you have to, that if you're not vaccinated, you have to test. If you don't test, you will be excluded from school.
Right.
So it doesn't define, the school exclusion is defined presumably based on the IDPH rules. I think different school districts are addressing that exclusion from school in different ways. There's no facts on the record about how the particular defendants in the courtroom are dealing with those exclusions from school.
Okay.
So there are no facts on the record about that. I know from personal experience that I have clients that have a variety of approaches to exclusions from school. Some of them just aren't letting teachers come to school. Some are going through due process to exclude them from school, which would be a hearing before, a board or before the superintendent. I can't speak for all of the school districts across the state, but that is what it says, that they have to be excluded.
They have to be excluded, okay.
Yes. But I don't have the motion in front of me. I'm not even sure that the plaintiffs plead that they've been excluded from
I'll have
school
to
at this
look
point,
too.
so.
Okay, all right, so,
What date was this rule of IDPH promulgated that you're talking about, Judge?
well, that's what I was saying, I have to go back and look at my notes.
You're talking about ISB's emergency regulation in part 6, right?
Yes.
Oh, ISB's rule, not
Yes,
IDPH.
no, IDPH has, I was wondering why ISB doesn't have the same thing as IDPH.
And when you're saying that doesn't have the same as IDPH, what are you talking about from IDPH?
That, it was my understanding that ISB is if you don't have a medical or religious exemption, and you don't test or you don't get vaccinated, then you're fired. What Ms. Jones has said is that you're excluded from school, and then each school is dealing with that exclusion in accordance with their policies.
No, I understand, I apologize, but when you're comparing it, I think it deals with another type of worker. I'm not sure what emergency IDPH rule we're referring to. Do you know which one it is?
She's talking about, I'm sorry,
No, go ahead.
The judge is referring to ISB's emergency rule, September 17th.
Yes.
And it has the exact same exemptions that you're thinking about with IDPH.
It does?
It has the medical exemption, it has the sincerely held religious belief exemption,
Okay,
and Ms. Jones got it perfectly, that if there's no vaccination and a refusal to test, then it's excluded from school.
Okay.
There's no implication whatsoever that you're fired. You're
Okay.
terminated.
All right.
It's just not there.
And Judge, I understand what Tom's saying, but what I'm asking is it appears you guys are referring to a specific emergency rule of the Department of Health that they've promulgated, and I'm just asking which one is that?
Well, that's why I have to go through my notes at
Okay,
lunch.
and if they know which one it is, they can tell us, but,
I don't think there's an emergency rule about healthcare workers or other workers before the court. You're just simply trying to understand the difference between that rule and the ISB rule
Exactly.
in context.
Yes.
So I don't know the citation to the, I represent school districts, so I don't know that citation for other workers. Mr. Verticchio may, but I don't really know that that's relevant.
Okay.
I think it's easiest to think about them in terms of the executive orders, because you've got the executive orders for the healthcare workers,
Right.
for schools, and they have parallel
Right.
exemptions,
Yes.
medical exemptions, religious exemptions, no vaccine, no testing, exclude.
Okay.
They're the same.
Okay.
because on the 17th, Judge, of September, ISB issued this vaccine emergency rule.
Right.
IDPH also issued an emergency rule, but it deals with
Healthcare.
quarantine, exclusion from school, etc. It doesn't get into vaccination of anybody within that emergency rule. The governor's executive order did, but the actual IDPH, to my knowledge, has not promulgated an emergency rule that seeks to compel vaccination on anyone. We actually talked about that at the first hearing, and I suggested to the court, purely conjecture, that IDPH has not promulgated an emergency rule as it deals with vaccination, because then they would have to compare that with the existing provisions in the actual Department of Public Health law and try to reconcile how they could do an emergency rule. But I'm not aware of any emergency rule that IDPH has created that addresses vaccination of anyone.
So 1:30, Your Honor, for class cert?
Yes, and if I have anything
Thank you.
further on this question, because I have a chart here, I'm looking through my chart, so I'll clarify that as well.
Thank you, ma'am.
All right, thank you, court's in recess.
Thank you, Your Honor.
Has everyone signed in?
Your Honor, again, okay if we leave our materials?
Yes, totally.
a copy of that yet? No, you, I can't believe they didn't consult you.
Forward to me what you got if you wanted to look at it.
You want, no, I'll send it to you. We might have to dismiss them out.
How's your family?
Good. My little guy turns 3 on Saturday.
Don't blink, man, go so fast.
I know. He had he started preschool this month. I just kind of like 2 days a week and it's just too fast. How's that, Graham?
There's no question. Oh, great. Last weekend? It's really special.
Oh, she's so pretty.
It's great. It's great.
They don't have the votes for any of that. That's just them throwing stuff around in the air, trying to stir the board up to converse, but they don't, it's not, as of today at least, they don't have the votes for it. So that's why you don't know about it.
Sounds good.
Yeah. Being on their letterhead makes it look like, so I don't know who did that. But. Well, people keep asking these questions, and you've been doing this too long, but even if you have questions, because I don't ever say, because it's just, but however. And it seems to be. June 28th is the primary, and election's the same as 6/4. I don't think they'll run. I think that's what the Democratic parties are telling me, that they're pretty much giving up any chance of winning any of those seats in the fifth. What's that? Seats in the fifth? Right now, one, unless for some odd reason Judy would retire, which there was speculation she would, but I'm not so sure. But she's 71 or 2, she's got a lot of money, but maybe she might. And Judy's a good justice too. Judy Cates, excellent justice. But if she would happen to not, because she's up for retention, if she would happen not to seek it, then there could be 2 candidates, but not sure. She hasn't said. Huh?
All right. Thank you. Have a seat. Just a housekeeping issue, my clerk pointed out here that, and I don't know if any of the attorneys know, so 2 attorneys aren't here. So one is for Eureka, it's either Jay Greening, Robert McCoy, or Jeffrey Gaster from Miller Hall and Triggs. They were here before and they've entered their appearance. Anyone heard from them? And then Cumberland CUSD 77, John O'Driscoll, Kathleen Gibbons, or Natasha De Leon. Anyone heard from them?
They're not here today.
Yeah, okay. Just wanted to make sure, because everyone else seems to have signed in. Okay. Oops, here's that other page. All right. Everyone ready? Okay. I'm gonna, before we go to the question we left with, or do we want to finish that first? we'll finish that first. Cause I was looking at my notes that I made up, and what I want to point out, let me find my thing here again. So, Executive Order 2122, that was issued on 9/3/21, extends the vaccine deadline to 9/19/21. It requires all these other things. States that nothing in the executive order is to supersede IDPH protocol. And the emergency amendments require vaccination of various medical personnel, and indicated unvaccinated staff who do not test shall not be permitted to enter the facility. That's what it says. Now, IDPH did not issue any emergency amendments requiring school personnel and other state facilities to be vaccinated. So, they did amend the Illinois Administrative Code 10 other times with regard to COVID-19, but they did not amend it with regard to school personnel and vaccinations. So that is where I was getting at with that. And correct me if I think I understand the school's position. Even though IDPH did not issue emergency amendments requiring school personnel to be vaccinated, you're saying you can do that under the Illinois School Code. That's the authority that I need to look to, that we all talked about this morning, and the prior hearing on.
My apologies, Your Honor. Which executive order were you referring to?
My notes say 2122,
Thank you.
issued on 9/3/21. Is that the right date?
Yes,
I have the
thank you,
order up here
thank
too.
you.
Can I speak to that briefly, Judge?
Yes.
And now that you've clarified that, because again, that's, you're correct, Judge. Once the governor issued his executive order, the Illinois Department of Public Health did not promulgate any emergency rules. I would proffer to you that if I was advising them, I'd have told them not to either. Because the problem that the Department of Public Health has is that the law specifically has provisions in place about vaccination and testing in the Department of Public Health Act. And now they're here, ISB is here, through Mr. Verticchio, and the school districts are here saying, well, that doesn't apply to us. Department of Health can stand, are they going to stand in front of you and say, well, that doesn't apply to us? Well, that's a 110% conclusion. The Department of Public Health Act does in fact apply to the Department of Public Health. And so for them to try to create an emergency rule regarding vaccination or testing, when the statute says this is how vaccination and testing works, I mean, Mr. Verticchio is a very talented lawyer, but to stand here and to argue the propriety of that would have been perplexing to say the least. So with ISB issuing their mandatory vaccination, they're trying to say, well, that can operate and the Department of Health Act doesn't apply. Obviously, we're arguing that the supreme authority on these issues is the Department of Health.
Right.
But they are at least able to stand in your courtroom and say these general provisions of the Illinois School Code allow us to do it. And then with the emergency rule of ISB, they're trying to give you the general rulemaking provision of the Illinois State Board of Education gives us the ability, and again, trying to get you to accept those arguments. I'm presuming they found that to be more palatable than an emergency rule from the very agency that is where the law resides. That's why I believe that at no point in time did the Department of Health ever create an emergency rule saying that we're going to mandate vaccination and testing, because it is, again, crystal clear that's irreconcilable with the law.
Okay. Anything from the school that we have not, or the state, that we have not already touched upon regarding that? Okay, here's my next. Do you
Sorry,
want to say
Judge.
something, Mr.?
Maybe just be clear to read your point that we made this morning. Schools aren't requiring vaccine.
Okay, let me go to that point. Because I went and read the executive orders over lunch.
The wording is, I think Mr. DeVore used the word semantics. It certainly says requirements, but then it says you don't have to do it.
Well, I mean, and we all, as lawyers, put great
Judge.
meaning into words.
We didn't adopt the executive order, Judge. On the
You what?
On the state level, there may be the semantic issue about the executive order. I'm not aware of a single school district that has locally required vaccine.
Even though the executive order says all school personnel must have at a minimum the first dose of the COVID-19 vaccine within 10 days of the issuance of this executive order. And then, I'm looking at, I didn't say the executive order. 2120, August 26, 2021. That is in section 3, subparagraph B. And then if you follow down to subparagraph F, state agencies, including but not limited to IDPH, ISBE, may promulgate emergency rules as necessary to effectuate this order. So I guess what I'm looking at is it says must. It doesn't say may, it says must. And you know as lawyers, we hinge on those words.
Of course it does. Of course it does. Robert Swain.
So, and then if you look at Executive Order 2122, it too, I do believe, Section 3, vaccine and testing requirements for school personnel. It does the same thing. And then we can go on and on, but go ahead.
So on a state level, there have been state mandates about vaccines for school staff. And I think we have all interpreted them to effectively mean that testing is mandatory, but because the only consequence of not being vaccinated is that you must test instead, that it's not actually a vaccine mandate. Again, we're all familiar with the wording of the executive orders and whether we describe it as semantics or otherwise. We all know what that says. On a local level, even the executive orders say school staff must be vaccinated or tested. Local school districts have not adopted vaccine policies imposing new vaccine requirements upon their employees.
But let me switch that on you again. So
Sure.
if we go back to the rules before the emergency amendments, testing was a form of modified quarantine. So if for some reason these emergency amendments are not valid, then how are you authorized to make your personnel test?
Sure. The modified quarantine regulations are IDPH regulations,
Okay,
okay? Adopted pursuant to the Illinois Department of Public Health Act.
okay,
That's an authorizing statute for the Department of Public Health. Okay? And section 2305/2M, that statute says, the provisions of that statute apply to orders of the Department of Public Health. Not that they apply to orders by local school districts or any other entity. So that gets to the issue of Department of Public Health regulates public health in the public sphere and issues things like quarantine orders requiring people to stay home, not go to school, not go to work, not go grocery shopping, not go to church. Okay? That is different in kind than local school districts developing their own mitigations and their own requirements for what happens inside their buildings, to the door, to the edge of campus, where our jurisdiction ends.
okay. Anyone else?
Yeah, on the requirement issue, Your Honor.
Okay.
Executive Order 2120, which is the one from August 26th, 2021.
Yes.
Section 3, C's and Charles. Schools shall exclude school personnel who are not fully vaccinated against COVID-19 from the premises unless they comply with the testing requirements specified in subsection D.
Okay.
Executive Order 2122, September 3, 2021. Again, Section 3, C as in Charles. Schools shall exclude school personnel who are not fully vaccinated against COVID-19 from the premises unless they comply with the testing requirements specified in subsection D.
Okay.
And then subsection D in both executive orders lays out the testing requirements. If this court construes those two executive orders, which are the linchpin of the claim on vaccine testing, as requiring vaccination
it's completely contrary to the plain language of the rule. You're gonna do what you're going to do, but there is no way that can stand given the language of the rule. Subsection C says with all the clarity in the world, if you don't vaccinate, you have to test.
Let me make a note of that. Okay.
Ma'am.
Yes.
Judge, it doesn't matter whether we're talking about vaccination or whether we're talking about testing. The law's the same for each of them. Now, I understand where it says in the rule, the ISB rule, mandatory vaccinations for school personnel. Okay, does it mandate vaccine? It says you gotta be vaccinated, and if you don't, then you have to test. Call it a testing rule, I don't care. One thing I want to clarify for you, Your Honor, is the Department of Public Health Act has 3 provisions that we're dealing with. We're dealing with subsection C, which deals with quarantine in general. We're dealing with subpart E, which deals with vaccines. And, ma'am, we're also dealing with subpart G, which deals with testing. To prevent the spread of a dangerous and contagious or infectious disease among humans, the department may examine, test, etc., citizens. So that's that subpart that deals specifically with testing. Now, within subpart C that we're referring to, with what is a quarantine, the court is aware that quarantine included the definition of modified quarantine. You're dealing with the emergency rule where they try to strip that out. And the language of what was considered, at least according to the rule, a modified quarantine included requirements for the use of a device or a procedure intended to limit disease transmission. Is a test a procedure intended to limit disease transmission? One could say yes. He doesn't, and again, I'm asking this court to find that emergency rule stripping this language was invalid, which throws that language back into the rule, and this court could say, well, a test is a type of procedure intended to limit disease transmission. That makes it a type of quarantine, which means under subsection C, due process is required. Set that to the side, Judge, and say, pretend that subpart C doesn't even exist. You still have subpart G, which is an independent statutory provision that you can't play games with the rules and try to strip the language out. Because in subpart G, it says you cannot test a citizen without giving them due process. So the court doesn't even have to. It's really got 2 independent analyses. Is modified quarantine still a part of a quarantine, which means subpart C protects a citizen? Yes. Irrespective of that, the other subpart G deals with testing directly. You don't have to interpret, is it a procedure intended to limit disease transmission under subpart C? You can just jump right to subpart G and say, irregardless of the gamesmanship of the rule, this independent statutory provision protects a citizen from being tested. I want the court to understand that. So even though, again, I want to be clear, we're asking you to throw that emergency rule out, which throws the modified quarantine language back in, which includes procedures intended to limit disease transmission. It also includes devices, which would be a mask. But as it relates to testing, there is a specific statutory provision that the rules, no amount of gamesmanship with the rules, could differentiate that and try to say, well, a test. Okay? So I wanted the court to be clear on that issue, is that that is an independent provision. It's the same with subpart, again, when the court's reading subpart E, it deals with the vaccines. So vaccine subpart E, testing subpart G, but also testing is under subpart C, if the court leaves the language of modified quarantine in because it vitiates this emergency rule. Thank you.
Your Honor, I'll be very brief. I think there's a critical distinction here. We're requiring the tests of employees. These are
Right.
not tests for citizens. And that is a monumental distinction. This is an employer requiring an employee to test. Mr. DeVore has again reiterated that his argument is statutory in nature. There is no distinction in that argument between public sector employers and private sector employers. If an employer cannot require a test because it is precluded by the Public Health Act, then no employer can require tests, no employer can require masks. That is an absurd proposition. Thank you.
Judge, that analysis the court doesn't even have to get into. We're not dealing with private employers here and whether they have a different place in this conversation than public employers. This is a school district, a school board. They have the power that's been delegated to them by the General Assembly. That's their power. Private businesses, I actually own one. We're not here asking to find that my private business can do anything to an employee. That's not even in front of the court. The question in front of the court is, what is the authority of this public body? And that public body's authority is confined in the law. That's why Mr. Swain and some of the other lawyers stood here and tried to argue that the law allows them to do this. I disagree with them, but they're at least making the right logistical argument that we have the power under the law. I don't believe they do. To say, well, none of the law matters because we're an employer and we can do whatever we want because private sector can, doesn't make any sense.
But isn't it true also the schools would not require, Mr. Feeney, these necessary tests if it weren't for COVID? I mean, they didn't require them before. So if it's not related to the COVID and it's not because of the executive orders, I guess maybe this might go back to you, Mr. Swain.
No, the schools are absolutely requiring the tests because of COVID. There would be no reason otherwise. My earlier comment is schools are currently implementing this because they are required to do so by the executive orders. But our point, again, if the court should have to reach that question, is that the districts, as employers, have the ability to require testing and have the ability to require masks. It's possible the court need not answer that question, but if we get to that, it's our contention that as an employer we do. And again, if the argument is statutory in nature, then there's no distinction between a public employer and a private employer. If the Public Health Act precludes an employer from requiring an employee to wear a mask, the Public Health Act, as we've heard again and again, the supreme authority would preclude that across the board. There's no distinction, and I think that highlights the flaw in plaintiff's case. Thank you, Judge.
Judge, I just talked to Mr. Verticchio, and again, my eyes are getting old, I apologize. When I was referring to the specific testing requirement, it's not subpart G, it's subpart D, as in dog.
Oh, thank you.
It looked like a G to me.
Okay.
When I was reading it on my screen, I didn't zoom in enough. Subpart D specifically deals with the testing requirements. Sorry.
And I
Okay,
can't,
that's what I was looking at too, but.
I can't resist, Your Honor, that Mr. DeVore would say subpart D is in dog, because he just went over subpart G that deals with testing of animals.
It does. So I was referring to myself. But when he said it, I started laughing.
Thank you.
And I zoomed in. But yeah, Judge, subpart D says that the department may order physical examination and testing and collect laboratory specimens as necessary for the diagnosis or treatment of individuals in order to prevent the probable spread of a disease. Subpart D, not G, is an independent basis for which the court can address the testing without having to necessarily look at the modified quarantine analysis.
Okay.
So thank you, Tom.
Thank you.
I was just surprised, I had not heard about subpart G before, Your Honor. I was scurrying to read the act.
He
Well, I was
couldn't
gonna go back and read
resist.
it. I'm like, okay.
I got new glasses last week. I don't have them on.
Oh my goodness. Okay, go ahead.
And Judge, if I might then just close my loop back, maybe even a little more succinctly than I thought. The provision Mr. DeVore just quoted leads with the department may. Department of Public Health may.
Right.
So when the Department of Public Health is issuing these orders, these are the procedures that apply.
Right.
Different in kind from school boards taking local action.
But then again, that takes me back to what authority does the school board have to mandate this if there's nothing from the Illinois Department of Public Health?
Sure.
You just say it's all independent under the school code.
No,
Okay,
so-
I just wanna make sure I understand it.
No, sure, so, okay, but some of those answers,
And then
right?
you said the
Now,
Constitution.
Constitutionally, actually, constitutional delegation is to the state board,
Right.
okay, so at a state level still. Schools are not requiring vaccines, they're not adopting those policies. That's only at the state level right now, and again, you will pass in the judgment of that. Okay. But the school board's authority to maintain safe schools, okay, comes from section 21.11, 10-21.11, okay? The authority to adopt policies for controlling chronic and infectious diseases. Mr. DeVore pointed out this morning that added provisions about addressing individual students. Okay, in this context, that means symptomatic or contact traced. And I can tell you, schools are literally, so our clients are literally in classrooms and on buses with tape measures.
Oh,
doing
I
their
know.
contact
I
tracing.
can't even imagine.
But I'm
What's
asking you to
going on?
imagine, actually, okay? They're not kicking entire rooms full of people
I know.
out
I know.
of school, okay?
And I'm
Helter
not
skelter.
implying that at all.
So even the point that this is supposed to be done on an individual level, it absolutely is under that authority. They are taking out their tape measures and calling us to ask, it says 6 feet and this one is 6 foot and half an inch. Can we flex it? I mean, they are literally calling us with those questions because they are undertaking all that individualized analysis when this happens in their buildings.
But
So-
let me throw this out
Yes,
at
yes.
you. I get that you get your own independent analysis, but you wouldn't be doing this if it weren't for the emergency rules, correct? IEMA would not be in effect. The other rules would not have been implemented.
So it has been judged in the last 2 years a very confusing and complicated environment for schools.
Yes.
But I'll tell you this, okay? There have been intermittently periods over these last almost 2 years when either there were state mandates that we presumptively had to treat as valid, or state declarations that schools should exercise local control and make these decisions locally. And when that was the direction from the state, school boards were making these local decisions. They developed individual local plans based upon their local conditions. Some had higher metrics, some had lower metrics. Some have buildings with more students where they can't socially distance very well. Okay? Some have buildings with a lot of extra space where they can socially distance. Okay? Some are able to implement one-way hallways. Some are able to cover lunch periods where kids can sit at different tables. Some can't because they don't have the room. Our point here on a local level is school boards, school districts need to be able to take all of those local factors into account. What are their local conditions? What is the spread in the community? What can they realistically accomplish within the facilities that they have? We can't just increase and shrink school buildings, year to year. We are more or less set with the building envelope, even though the number of kids fluctuates. That's part of the difficulty of running a school. Okay? So when the state said, for a period of time, these are all local decisions and school districts should develop systems of layered mitigations, we went through many, and they were many difficult but deep diving meetings with our clients where they considered many different mitigations and how they might apply locally and which combinations would work best for them. So yes, absolutely. In the absence of state mandates, school districts are figuring this out for themselves based upon their local conditions. Absolutely. And as they've been contingency planning, now these 2 or 3 weeks since they've been back from break, especially those that are parties to the lawsuit here, of course, which is quite a number of school districts, okay, which again we all collectively represent, okay? They are contingency planning things like, where did we leave our own local plan before the latest set of mandates came last fall? Does it make sense to return to that, which would then, if local control survives, okay, would presumptively then become the new default again. Do we need to update those plans? Do we need to update it based upon updated conditions in the communities? Do we need to be prepared, okay, to change the plan based upon the contours of orders that might be issued? Okay? These are all the contingencies that they are preparing to make locally right now.
Okay.
Absolutely, Judge.
Oh.
Your Honor, reconciling what my colleague says about this local control and all of these plans, etc. There's a way to reconcile what Mr. Swain says with what we're asking. The school district's ability to create these plans, does that include the ability for them to require vaccination or testing? Does it include their having a local ability to force masks as either a treatment or a device intended to limit the spread? Call it what you want. Can they go so far with their ability to manage their own district that they can implement those types of measures for the general public health? Or is that something that the legislature has said on those issues, that's for the Department of Public Health? Section 2, the State Department of Health has the general supervision of the interests of the health and the lives of the people. It has supreme authority in matters quarantine and isolation, may declare and enforce quarantine and isolation when none exist, may modify or relax when it's been established. Judge, that's pretty broad language. All of the history of our laws that deal with these matters of public health and rules lies with the health department. I don't disagree that the school districts have the ability to create some planning, but their planning can't disregard state laws when it comes to certain matters. Being able to create a local plan doesn't mean they can tell their teachers that you're going to either vaccinate or submit yourself to testing, laboratory analysis, etc. And if you don't, we're going to send you home. Recognizing that they have some ability to manage their schools is not inconsistent with you saying you can't go that far. Same thing with, when we get to it, the exclusion from school and the macking, etc. You can create local plans to try to, as he talked about, how far apart are you setting children? Stuff. We're not here talking about that. I mean, I've heard so many things in the last 2 years. We're talking about football helmets and hairnets, and we're not talking about any of that. We're not talking about pink eye. We're talking about vaccination, testing, exclusion, and masking. And those issues, if you read the laws, is in the Department of Health Act. And for them to suggest that their inherent authority covers all these things, there's no support.
So just very briefly, and then we'll say McDonald.
Okay.
Every time I hear Mr. DeVore discuss the Public Health Act, he discusses the breadth of their power, but I haven't yet once heard him discuss the limitation in Section 2M that says the provisions in this act apply to orders of the health department. That's the scope of the Public Health Act.
Okay. I think we've exhausted
We've
that.
gilded that lily.
Okay, let me look, I tabbed this right here, let me see if I had, nope, I asked you about that. I had something here, I gotta find it. Give me one moment, please. 'Cause I have so many binders. Going back to you and how you're saying the Illinois Department of Public Health does not apply to the school. So I'm looking at, the, school code 5/27-8.1, health examinations and
Absolutely,
immunizations.
absolutely. Yes.
And that talks about here, in compliance with rules and regulations with the
course.
Department of Public Health, they shall promulgate, and then, you know, they have
Mhm.
all these pages here. And then, I think we talked about this,
Yes,
I don't know,
Judge.
was this case or the other case?
They,
where-
they seem to melt together. Judge.
Yes.
Yes, and please don't misunderstand me. I'm not suggesting I'm not suggesting that the Department of Public Health doesn't apply to schools at all.
Okay,
What I'm suggesting is the procedures in that act apply to orders from the Department of Public Health,
okay,
okay? That's number one,
okay,
by definition in the statute in section 2M. And also, and this is, I think, what we discussed the other day, there are specific provisions in the school code that say, Department of Public Health, this is how you should regulate schools. So the Department of Public Health, for example, I think this is 27-8.1, okay, is in charge of deciding which vaccinations students must have to
Right.
attend school.
right, yeah,
Without confusing tomorrow, okay? But the reason there's a statute in the school code that says, Department of Public Health, come tell schools which vaccines to require, is because the Department of Public Health wouldn't otherwise have that authority. The General Assembly had to give it to them in the school code.
right,
Right, okay? And, okay, so the General Assembly gave the Department of Public Health authority in the school code to determine which vaccinations students must have to attend school. They gave the Department of Public Health authority to issue guidelines to govern those chronic and infectious disease policies. Okay? There are a couple others, they escape me, but they pertain to things I think like the Health Life Safety Code. Okay? There are specific provisions in the school code that define what the Department of Public Health should do vis-a-vis schools. There is not a provision in the school code that says the Department of Public Health should apply its quarantine rules to excluding sick people from schools or to excluding close contacts from schools. There's not a provision that says the Department of Public Health should apply its rules to require the wearing of masks. There's not a provision that says the Department of Public Health should apply its modified quarantine definition to school operations. None of that exists in the law.
right.
And so that is where I think the fundamental difference lies between Mr. DeVore and I.
But if these school boards have such independent authority to do this, why did the governor mandate that the schools comply with IDPH and ISB's joint guidance?
Because the joint guidance is actually provided for right in the school code. That's 10-21.11.
I'll write that down.
And I'll confess to you, part of the reason why I am so intently focused upon local control and more or less agnostic as to the authority of the state officials is because our many clients have just as many different views about whether or not the state officials should be issuing these mandates to them. Okay? But Mr. Viticchio speaks to that quite well. Okay? But on a local control standpoint, okay,
So, I'm sorry, go ahead.
the Department of Public Health Act isn't dragged into the school code in its entirety. There are specific things the Department of Public Health is authorized by the General Assembly to do in the school environment. And there are the specific things set out in the school code.
So if that's true, then why did the joint guidance say that the Illinois Department of Public Health and ISB, why does the joint guidance say that the local health departments have the ultimate authority? If they have this independent authority, why not say that? Why not come out and say that? But they didn't. They said the local health departments have the ultimate authority.
Which, I confess now, Judge, I'm not sure which provision you mean. Ultimate authority to do what? To
require, you're saying that the overall gist of it is that the local school boards have the independent authority to do what they want, that they don't have to follow the Illinois Department of Public Health. So if that is in fact the case, and I'm really chopping it up here, then why doesn't the joint guidance say that? Why doesn't it say, local school districts, you have the independent authority to do what you want? Why did they say the local health departments are the ultimate authority? That's what the joint guidance says.
Okay.
Your Honor, just for clarity in the record, the joint guidance doesn't say that. The joint guidance in September that's attached as an exhibit to the complaint says that the schools are making that decision. The joint guidance that came out on January 11th, 2022 says that the schools are making that decision. To the extent the phrase that you're referring to is in the joint guidance, it's in the earlier joint guidance.
Of course it is.
I mean, things, believe it or not, mitigation of COVID-19 is a fluid situation.
Yeah.
So the law as it sits, the record in front of you as it sits by the plaintiff's own exhibits to their own complaint, the joint guidance provides that the decision on close contacts lies with the school district.
Judge, if we've argued, sorry, Mr. Swain, the joint guidance we're arguing is because it's not a promulgated rule, it's not authoritative. But Your Honor's right. The versions that came out at the beginning of the school year, which merely, again, it's not authoritative, it just merely lays out information, said that the school district, or that the local health departments were the final authority dealing with these matters. As this situation has progressed, now the new guidance says, well, the school districts can do all of these things, right? So they changed their guidance to try to comport with what they're wanting the courts to do. Whether or not the school district or the health department is the final authority is not something that guidance issued by administrative agencies is controlling on. It's not controlling on your determination. You determine who is. And if you want to agree with Mr. Swain, that's your purview. But joint guidance doesn't dictate who has the decision making, because before it said it was the school, the health departments. Now it says it's the school. And I would humbly proffer to you, ma'am, the guidance now says it's the school, because if it still said that it was the health department, then their argument the state's trying to make about, it shouldn't have to go through due process would really be diluted if their joint guidance still said that. So,
Mr. Lamb, could you please repeat the last sentence?
Can you repeat what you just said?
what I was saying is that if the joint guidance hadn't changed to now say, well, the school districts can make these decisions, and it still said what it said earlier on, that it's the health department, then our argument that due process is required would be a lot clearer.
Right.
Right. So
I follow you.
But again, Judge, we're arguing that joint guidance is not authoritative, wasn't promulgated under the administrative procedures rules, and it means little of nothing. It certainly is not authoritative to explain to you what the law is. You decide what the law is.
Anything else?
Judge, I'll agree with both voices from over both shoulders.
All right.
The guidance is not regulation, absolutely. I agree with Mr. DeVore. The guidance is authorized by that provision in the school code,
Right.
21.11. And certainly, agreeing again, I think it's up to Mr. DeVore. The guidance cannot be more limiting than even the Department of Public Health has authority to limit in the first instance. Meaning, if the guidance says, and I think now I'm understanding the provision you're looking at, if the guidance effectively says, local school districts work with your local health departments, okay, then because this is all being done on the purview of the Department of Public Health's statutory authority to begin with, they can't expand their own authority, right? And so if their authority, okay, is either to implement their act as to their orders, or to implement the provisions of the school code that give them a specific authority to participate in school operations, then they're telling schools to work with your local health department as to this handful of local school provisions that we are otherwise authorized by the school code to be participating in.
Okay, I follow that.
Yeah,
Okay.
thank you.
All right, I don't wanna open up a can of worms, but did that raise anything else?
No, just 21-11, Judge, keep in mind, that deals with chronic infectious disease.
Okay,
It doesn't deal with even the issue that we're here in front of us. But what Mr. Swain continues to say is that their authority is so broad that we're in fact going to turn school districts into the managers of public health. They can decide who's a public health risk and who isn't. And for them to say that exclusion from school is not covered, again, it was in the rule until they tried to take it out, exclusion from school. So, again, we've not heard from Mr. Reticchio, and I'm not going to put him on the spot because I'm just not going to do that. You haven't heard him stand up and say, well, yeah, the school districts have their local inherent authority to do whatever they want, irrespective of what the state says, right?
I don't think you've heard anyone say that.
Oh, okay.
Your Honor, I don't think this has opened up a new can of worms,
Oh.
but if you're
have you
asking.
been here all day? I
I have.
Okay.
I just
Come
been
on
quiet
forward.
in the back and I couldn't help myself. But I do have one issue that I, sorry.
Identify yourself for her
I'm-
case. I know who you are, but go ahead.
Thank you. Fraser Satterley, Hodges, Louisiana, Eisenhammer, Roddick & Co. Here on behalf of North Max CUSD 34, Marion 2, Triad 2, Jasper 1, and Yorkville 115. Do I need to repeat that or slow down at all? Okay. And I know we haven't been talking about this, but we did start the day out talking about the balancing of harms, and I think I would be remiss if I just didn't bring up this point briefly, as we seem to have come, I think,
Full circle?
to the end of the discussion about due process under the IDPH, or rather the Public Health Act. And obviously that goes to likelihood of success on the merits. I don't need to add anything to that particular discussion. I concur wholeheartedly with what my colleagues have said here today. I disagree that plaintiffs can make out a likelihood of success on the merits, but you and I might differ on that point too. But obviously there are 4 other elements in order for the plaintiffs to be granted a temporary restraining order, which is an extraordinary form of relief, Your Honor. And one thing that I think has not been mentioned today, but certainly warrants it, is that these plaintiffs, particularly employees of school districts, Your Honor, cannot make out an irreparable harm, and they have an adequate remedy at law in the form of money damages. There's case law on this that's well settled. There's not an irreparable harm for temporary loss of income. An adequate remedy at law being money damages, that is the quintessential remedy at law. So this case is slightly different than the student case in this regard, and it has been mentioned today, but ultimately, if this court makes a decision on the merits of this case that the state mandates are invalid and that the school district doesn't have the authority, which again, I'm not saying, but if this court ultimately rules on the merits of this case that the school districts do not have the authority to exclude these folks who refuse to submit to weekly testing, because again, it's not a vaccination requirement, it's testing. They're excluded based on a failure to wear a mask or failure to submit to weekly testing. They would be subject to, they would be entitled to back pay. That alone is fatal to their claim, fatal to their motion for a TRO today.
Well, let me ask you this. I get what you're saying, but they are subject to losing their jobs, which is their salary, but they're also subject to losing their pension, their retirement, their health benefits. I mean, there's a huge potential if they don't test or if they don't vaccine and they lose their job. So respond to that for me, because that's what I've been thinking. I mean, isn't this punitive? I mean, yes, I understand. They do have the remedy. You can bring a lawsuit, and we understand all that. That takes years. I mean, this is immediate.
Sure.
And people who may have been working for 30 years are now going to lose their job. They're going to lose their retirement, their pension.
Sure, I have 2 points on that. Your Honor.
Please,
Okay.
thank you.
First,
And don't say they haven't lost their job, because let's do the hypothetical that they could lose their job. Because I think 186 has terminated someone because they weren't vaccinated. So some teachers have lost their job. Whether 186 is in this case or the other case, I cannot tell you. Maybe they're in both.
so if we're working under hypotheticals, that is the entirety of Mr. DeVore's complaint in this matter, Your Honor. There are no specific allegations in his complaint that allege any specific facts about what any specific school districts, what actions they have taken with respect to the named plaintiff's employment. And that's an important point for this court to understand.
Okay.
So he's sitting here asking you to make sweeping advisory opinions with respect to a school district's authority to take action against its employees. But he hasn't actually fled any specific facts. It's problematic. It's a matter of law.
Okay.
The second, talking about due process, their pension, their livelihoods. It's been said multiple times, but I'll say it again. He's talking about due process under the Department of Public Health Act.
Okay.
That's an inherently different animal than due process rights that that employees are entitled to at school districts. So I don't want to go too far down this road, but since Your Honor asked, I'll certainly talk about it. The employees have due process if their employment is terminated.
Okay.
I don't want to be quoted on this, but I believe these are all, school personnel encompasses not only teachers, but teachers'
Right.
aides, okay?
Sure.
But at the very least for tenured teachers, there's certainly a due process requirement. Before school districts can take any adverse employment action against any employee, but in particular tenured teachers, they have to go through a number of steps.
Right.
A notice of remedial warning. Ultimately, if that isn't met, the conduct isn't remediated, they can be terminated. But they have the right to a hearing before the Board of Education. And then not just that, Your Honor, then they have 17 days to request a hearing from an ISB-appointed hearing officer.
Okay.
And then after that, they can appeal to the courts. But only after that process. That's a lot of due process, Your Honor, that protects those rights that you just talked about.
Okay.
Pension, employment, future employment, all of that. They have the right to object to or take issue with any adverse employment action taken by the school districts with respect to their employment under that particular process. This is a wholly different beast.
Okay. Did I cut you off from something else you were going to say?
It's possible. But I think that my points have been made.
Okay.
This is not an appropriate, they cannot make out the elements for a temporary restraining order, Your Honor.
Okay.
Because they simply cannot show an irreparable harm or that they don't have an adequate remedy at law. Thank you.
Thank you.
Well, that was a rabbit hole, Judge. I wasn't sure how we got to that, but so be it. Adequate remedy at law, and just for whatever it's worth, Judge, when you asked about, you believe that there are teachers in Springfield that have been terminated, in fact it's true, and one of them is sitting in your courtroom. The adequate remedy at law, well, let's see how that works. You get a vaccinator test. The law says you don't have to, and if you choose not to, you might be quarantined. But let's throw that to the side, because somehow or another, that law doesn't apply to the teachers in the context of their employment, according to my colleague. But what's your adequate... Judge, we have not pled anything for money damages in this case. We are here asking you to find they have a right to be protected under the laws of this state. That's what we're here asking you to do. Protect the law protects them. Please use it to protect them. We're not here asking for money. We're There's no prayer relief for money damages. And to merely suggest, well, you could sue for money damages, let's see how that would work. So we have an educator who gets terminated, or not terminated, I'm sorry, voluntarily terminated, and so they can't work. They're not working. Go find a lawyer, bring a lawsuit against the school district who will fight you with taxpayer money, and then see if you can win a lawsuit and potentially get some money. That's not an adequate remedy for what we're claiming is the violation. We're claiming that trying to force these citizens to do something that the law says can't be done to them and that the legislature has never given these public bodies the authority to do, that's the right in need of protection. That has nothing to do with money damages. And to say it's not irreparable, every day that goes by that these people are being subjected to take the vaccination, take the test, or be subjected to going home without pay, that's irreparable. You cannot get that back. We have pled. Each of the school districts currently have the following policies in place. Educators may submit to either being vaccinated or to undergo weekly testing for COVID. And if he or she refuses, is subject to disciplinary measures up to and including termination. Educators must submit to wearing a mask while on school property, and if he or she refuses, is subject to disciplinary measures up to and including termination. Educators are involuntarily wearing masks while on school premises and have never been provided due process to object. They're involuntarily submitting to weekly testing in order to prevent being terminated from their employment. Voluntarily, I didn't write that in there. And have been provided no due process. They're not current for positive for COVID. They're not exhibiting symptoms. They've never been determined by a local health department to be a public health risk. Whether you grant my clients any relief or not, the basis for it is in here. The basis for it's in here. This is not a claim about money. They're not here asking you for money. They're here asking you to protect them from the abuses that they're suffering from the hands of a public body at the state and local level that do not have the authority from the legislature to do what they're doing to them. That is irreparable, and it's not a money case, Judge. Thank you.
Final word, Mr. Verticchio.
And thank you, Your Honor. I mean, we've come full circle because when we started, I said you had told me I could say a word or two about irreparable harm. So oddly enough, we got there. The court commented that some teachers have lost their job. And I keep harping on it, and maybe it's because I'm an old lawyer and rules count.
Sure.
This is a TRO on the record. There is not one morsel of record that a teacher has lost his or her job.
That's right.
It's not here. It can't be considered. Period.
Okay.
Lose pensions, lose livelihoods. Not one thing in the record. It's not here. It can't be considered. This, I don't have to tell the court this. This is serious business. Every bit of this is serious business. And there are obligations and burdens that a movement for this extraordinary remedy must carry. And standing up and just saying things without it being in the record doesn't cut it. Irreparable harm. The harm that the plaintiffs are subjected to if the TRO does not grant is you have to wear a mask, you have to test, and if you won't do either of those, you could be subject to discipline. That's the harm of what happens if the TRO does not issue. And the court, I urge the court to to separate the harm if the TRO does not issue as opposed to the merits. The merits. The claim of we are entitled to procedures under the Public Health Act is the merits. That's the claim. And in the meantime, what harm are teachers subjected to? Masking, testing, or possible discipline. That's the harm. And the court must determine if the TRO doesn't issue and the case goes on to reach the merits, is that harm irreparable? Is requiring masking irreparable? Is testing irreparable? Is possible subject to discipline irreparable? And I submit to the court that the answer to all of those is no. Masking could be, I think, based on, in the student case, the affidavit of the doctor that Mr. DeVore submitted. Masking, I guess it's possible, could be irreparable if you had a medical condition that triggered as a result of you having to wear a mask. But we know here that can't be irreparable. Why? Because the executive order that requires the wearing of a mask has a medical condition exemption. If I have a medical condition such that I cannot wear a mask, I'm exempt. Therefore, masking cannot be irreparable. There has been no case, not one, in this country that has concluded that masking is irreparable by virtue of a published opinion. We've given you, in the Austin opposition memorandum, Your Honor, at pages 36 and 37, and then there's a string cite longer than it needed to be at footnote 27 in the Austin TRO opposition that gives you cases from across the country.
36 and 37, you said?
36 and 37 of the Austin opposition.
Okay.
In footnote 27, cases from across the country concluding masking is not irreparable harm. But you don't have to go that far.
Okay.
Because on September 24th, 2021, you concluded that. You issued an opinion in the Murray case denying a TRO, a masking TRO, concluding that the plaintiffs had failed to show irreparable harm.
Okay.
Under the same analysis, there's an exemption. If masking could be irreparable as a result of a medical condition, you are exempt from wearing a mask, therefore it can't be irreparable. Testing. Your colleague
Asher?
in Lambert,
Judge
Lambert
Asher.
versus Pritzker, Judge Asher. October 8th, 2021, paragraph 13 of her opinion, quote, no authority supports the position that the requirement of conducting a minimally invasive testing procedure on a weekly basis is irreparable injury, period, close quote. No authority. In the Strite case, which we cite to you, the Northern District of Illinois, the court observed, quote, the saliva PCR test is one of the most minimally invasive tests available, as it only requires a small vial of saliva and can be completed in a public setting. To be blunt, the Shield test is simply spitting, technically drooling in a tube, close quote. No irreparable harm. That leaves us to possible discipline for refusing to mask or test. Mr. DeVore says, we're not suing for money damages for discipline for refusing to mask or test. Well, I know why. There's no record that anybody's been disciplined in this case for refusing to mask or test. But that aside, Ms. Satterley outlined the law in this state perfectly. And we cited you the Webb case. It's at 275 Illinois Appellate 3rd, 674, 677. Quote, money damages are ordinarily adequate compensation for the loss of employment, even given the possible attendant stigma or difficulties in finding new work, close quote. In the COVID arena specifically, the Cornaya decision, Exhibit 11 to our opposition, the Kane County Circuit Court specifically determined no irreparable harm because a wrongful termination lawsuit exists. And the law in Illinois is that is an adequate remedy at law, and that it takes time. That's an unfortunate fact that we live in. Plaintiff's response. Well, this is a continuing violation. There is a body of case law that says if you can show a continuing constitutional violation, that's irreparable harm. We know that doesn't apply here because Mr. DeVore confirmed to you on January the 5th, and he confirmed to you again today. The plaintiff's theory is not grounded in the Constitution. The plaintiff's theory is grounded in a statutory procedure that they believe they are entitled to under the Public Health Act. The notion of a continuing constitutional violation satisfies irreparable harm, has no place in this case because we have admissions from the plaintiff's own mouth that they are not seeking a constitutional violation. Beyond that, there is no case anywhere that has concluded that testing or masking is a constitutional violation. So I guess it's not a surprise that plaintiffs are not seeking that remedy. The record, Your Honor, and the law, masking, testing, possible discipline, it's just not the stuff of irreparable harm. And for that reason alone, the motion for TRO must be denied.
Thanks.
Now we're getting somewhere, Judge. Boy, the obfuscation just continues and continues, and it almost gets to the point where it becomes gaslighting, Judge. Where we're talking about the masking is not irreparable and the testing is not irreparable. Judge, we're not even talking about that. We're talking about the rights that people are afforded under the statute. We've argued it in here, and Mr. Berticchio is right, where we raised the case law that says if you have a continuous deprivation of a right, a fundamental right, that can be irreparable. The judge doesn't have to get into the analysis. Ask yourself, if citizens are being told every day, you have to do this, and you believe the law protects them from having to do that, if you decide that, that's irreparable, Judge. Now, the fact of the matter is, the Illinois Constitution says people are protected, life, liberty, pursuit of happiness without due process of law. What does that mean in a general sense? You don't have to go there because the legislature has told you what it means for due process. It's protected by the Illinois Constitution. They've told you what it means in the context of us being in front of you today. The statute has already done the work for you and said people's rights of due process on these issues are protected, and we've codified it. That's what's irreparable, Judge. If we can't stand in a courtroom and say the law protects people. Now, I understand the arguments they're saying this law doesn't protect people. Set that aside. If you say this law protects them, every day that goes by that it's not being allowed to protect them, they can never get back. It doesn't matter that it's a mask. It doesn't matter that it's a test. It matters that there are measures being put in place to try to limit the spread of COVID. We're happy to be mask and testing, but measures are being implemented, and it's being forced upon people contrary to what the statute says, Judge. That's the harm. They want to talk about the cases that were in front of the other courts. Well, wearing a mask is not irreparable. Judge, what's irreparable is that the people have a right to object to wear that mask without being forced into the situations they're being forced. That's irreparable. Whether that was argued in front of the other courts properly or not, I don't know. I wasn't there. But to the extent my colleagues allowed that conversation to be about masks is where they went astray. It's not about masks. Mr. Verticchio is trying to drag you down that rabbit hole. And this, I'm not going to let it happen. Whether you agree with my clients or not, I'm not going to allow that to happen. It's got nothing to do with it. Testing the same way. Well, if we're submitting to these non-evasive tests, then it's not irreparable. What's the harm? The harm is, Judge, the law says they can object. We don't get into the varying matters of degree or whether or not it's an invasive test or not an invasive test, or it's just a mask, or now how many masks you're supposed to wear these days. I lost track. 4 or 5? Doesn't matter, Judge. The law says due process under the law, which is guaranteed, been codified, says they can object. Is that a good law or not? I don't know. Maybe they shouldn't be able to object. Legislature can change it all they want. And again, as I told you when we started here today, I'll walk in this courtroom and dismiss this case and look my clients in the eye and say the legislature, they did what they thought was best. But until then, we got what we got. And it is irreparable, ma'am. It is irreparable to allow every day to pass to not allow this law to protect these citizens if you find that it should be protecting them. If you say they have a right under the law, under this Department of Health Act, if you say that right, they have a right to be protected, that's irreparable. You can never get that back. It doesn't matter that, well, it's just a mask. It's not even part of the conversation, ma'am. It's not a part of the conversation. In the case law that we've cited to you, that Mr. Verticchio acknowledges that if people's due process rights are being violated, you can't ever get that back. You can't ever get that back. And again, we have in our brief told you, Illinois Constitution, again, we all know that. It guarantees life, liberty, pursuit of happiness without due process. We don't have to get into an analysis, and I never got into the analysis of whether or not that general constitutional provision needed to be broken down because, again, the legislature had already done the work for you by saying, here's a statute that covers these particular set of facts. We're saying what that due process is to protect their life, liberty, pursuit of happiness. Apply it to the people of your state. For that reason, Judge, there is irreparable harm. Thank you.
All right. Let's take a 5-minute break and then jump into class certification. Sound good?
Yes, ma'am.
Thank you, Your Honor.
All right, thank you.
Your Honor, just very briefly, I just wanted to note for the record. Oh, I'm sorry. Randall Slade on behalf of Rowan Clemson. We previously rested on our briefs. I don't have anything to add to what my colleagues on behalf of the school districts said today, but I just wanted my presence noted in my objection and resting on briefs.
Thank you very much.
How long do we want, Judge?
5-10 minutes, no later than 3 o'clock, but just take.
So a lawyer,
I just wanna take-
5 minutes, we'll call it 3 o'clock.
That'd be perfect.
and cleans it out,
Yeah.
so.
My husband doesn't even venture, he's like, I just.
There you go.
Thanks, girls.
Might need to grab it from you
I will
before I
not,
leave.
yeah, absolutely.
Oh. He was pointing out
He was
outlets
pointing.
earlier.
Here's one. Just before we get started, this will be me.
No. Over there, yeah. Is there one on the microphone? No.
That's okay. There isn't one on the table. There is, I have it there right now, but I'm gonna have to grab it.
You can talk loud, Tom, I don't care. Got 4 minutes.
What is that, Tom? If it's 5 minutes, we'll just, we'll give us some help.
I don't know.
One an appeal today. Go figure. The fifth after the game.
I was just gonna say, it must be makes sense.
Yeah. Oh, I usually got, Judy Cates usually gives me just rails stick that in your face. It was in that first possession. I get it. You ever tried it? First possession?
Judy Kate, I go back with Judy Kate.
I love Judy, she's awesome. I always tell her, I said, I never prepared for my oral argument, Judy, because 30 seconds into my argument, you stop me and start picking out all the weaknesses in the case, and she just starts laughing.
Judy used to be a school board member.
Did she?
Yeah, in Belleville, 201.
Yeah, I like Judy, she's cool.
Yeah, she sued her own school district.
She did? She might kind of people that.
Over, while she was on the board, over.
While
they
she
were-
was on the board?
Mhm. They were adopting a dress code. She sued the Belleville School District over their dress code. She lost.
Did she lose?
Yeah,
Oh, that's all right, she still filed it.
she did. She lost pretty handily. That was
She
fun.
filed it in that county?
She filed it in St. Clair County. We removed it to federal court,
Oh, okay.
and then she lost in federal court.
What was the federal issue?
She pled First Amendment.
Oh. Okay. Boy, it's kind of like the Robert Cruz case that he filed that thing. I heard the school board removed him. Did you guys hear that? At your school district?
Oh, yeah, I saw that on the news,
Yeah, they passed a resolution removing a school board member.
Hey, I just got a text that we're live. That people,
Oh,
yeah.
thank you.
Larry did start preschool. Can I scroll? Oh, that's just, yeah, you can scroll. Okay. That was a text message, but yeah, scroll through whatever you want, there's nothing. I said quotes. Oh yeah, that's so my nanny has a 1.5-year-old that she brings, yeah. So, he'll be 3 on Saturday, yeah. It's nice.
Is that your house?
Yes.
You guys moved, right? Again?
Yes.
Okay.
Moved into Highland Park.
I'm not reading your text message.
Oh, I know.
Okay. He's just.
Yeah, he's fine. You've got, because you didn't, Christmas was probably not super, like,
She doesn't
get it yet.
quite
You
get
didn't
it.
get
But so my husband's brother has an 18. No, I'm sorry. Brady's almost 2.
Okay.
So they're relatively close in ages.
Oh,
And that
that's
was fun.
fun.
That
Yeah.
was fun. But yeah, she kind of lost on her. And
Yeah.
at the end of the day, they would have rather played with like the boxes
Yeah.
and the tissue paper. So
Well, he would have rather played with the paper, like, he would have unwrapped boxes all day long.
yeah, that was
He really got into unwrapping them. Yeah.
Bring enough to share? Enough to share? Did you bring enough to share?
Bring a bottle of wings.
This is good.
You like wings?
Yeah, but it was marketing genius.
Yeah.
It was really, you can get other than that shit was good.
Absolutely, I agree 100%.
Uh,
Well, it's a lot of that. I mean, the quality element is important, but you're right, a lot of that's
there. But have you been to Buffalo Trace?
I have not.
And seen a bottle? It's really cool.
Is it pretty cool?
Yeah. It's, if you get a chance to go Buffalo Trace,
Okay.
it's really neat. And Four Roses, actually. But Woodford's my favorite.
Woodford's I was getting ready to say my go-to is Woodford. I got like the big bottles.
The double oak?
Yeah.
Now, wait for it though. Have you had the double oak?
No, I have not.
Okay, you can only get it at the distillery.
Okay.
And it comes in smaller.
Okay.
Okay.
Yeah, that one Woodford is my go-to.
Yeah, it's good. So it's a double oak. Wouldn't say that it's doubly, it's double oak.
Okay.
Double oak.
All right.
But it is good. It's just different.
But you have to get it there.
You have to get it there,
Okay.
which makes it fancy.
Now I'm gonna have to do that.
Okay.
She's from down there.
Oh,
She
okay.
knows.
You see the Kentucky number pop up.
That's true when Kentucky pops up.
Yeah.
I'm used to it now.
Yeah.
Randall, you're gonna do something on class?
Yeah, just very.
As
So
it
like-
relates to the injunction, it's not necessarily, it's we're dealing with a new process on it, so it's. So the classifications now last. This is what we're gonna do.
Oh. Everyone get some coffee?
Red Bull. No. Once I turned 50, my kid said I couldn't drink more than one a day. What are you laughing at, Tom?
All right, let me get my notes here for. Hold on, I started typing the last hearing on the wrong thing. Let me change my notes over here quickly. Okay. Then let me get the right binder here. So with regard to, let's go back on the record. So with regard to the motion to certify class, are we gonna incorporate anything from the prior hearing? I just wanna get, are we sharing transcripts again, or what are we gonna do?
I think they've already been filed, Your Honor.
Okay, I just wanna make sure, so.
I thought your order included the cross-filing.
I just wanted to clarify it, and to make everyone aware that I was here before when we argued it. So we
I don't have a whole lot to add.
Okay.
As far as the order, again, on the request to certify the class, it's not a long, complicated request. Mr. Berticchio seems to think that makes it fatal. I seem to think it makes it that straightforward, in whether the court grants it or not. We would ask you, as we did before, to review the September 21st ruling of Judge Tromper in 21 MR 91. Review the ruling of Judge Grunke in 2021 MR 112. It's been transferred here also from Hillsborough, Montgomery County, entered 9/17.
Now, is that before Judge Asher?
No, that was Judge Grunke in Montgomery County.
But you said it was transferred here?
It's the 500,005 case.
Thank you.
Yeah, so there was an order certifying the class in the Hillsborough 500,005. There was an order certifying the class in Judge Tromper's case, which again is the main case here, the Montgomery County,
Right.
McCoupin 21 MR 91.
Yes.
Now those certifications, Judge, so we're clear, in Judge Tromper's case was a certification of the class of students as it related to exclusion policies. With Judge Grunke in Hillsborough and Montgomery County, it was a certification of the class as it related to the masking policy. But again, we think the analysis to the court, again, especially Judge Tromper goes into great detail. I think the analysis applies here because we're talking about, again, an issue of law that predominates over any individual issues. And again, Mr. Berticchio argued ad nauseum about discovery, et cetera, trying to conflate this into a complicated tobacco settlement or asbestos settlement. We're not there. The court quite simply can go through the analysis and say, should any order that the court might grant giving relief to these named plaintiffs, should it apply to the other similarly situated educators in those school districts? I would point out to you as well, Mr. Feeney will like this, that also in Clinton County, Judge Schieffer in one of the Clinton County matters, and I'll find it because I know Tom's going to holler at me if I don't. Let me pull it up for the court. One second, ma'am.
It's fine.
Mr. DeVore, I believe I think they were an MR case, and it was 06 and 07. There were two cases.
Correct.
21?
For,
No. 21
The
MR?
Clinton County case, I believe, I'm going from memory, Your Honor, and that we've had a lot of these. I think it was 2021 MR 6 and 7 in Clinton County, both involving Carlisle school districts. Two separate cases, we argued them as one.
Yeah, and in that case, even though I think Mr. Feeney and I would agree, the way that Judge Schieffer went about ruling on the certification, there really wasn't a motion to certify in front of him, but Judge Schieffer went through the analysis and said, I'm certifying this because he didn't want to have to come back with joinder and have all kinds of kids jump back in that case. He says, I'm applying it to all similarly situated. And Mr. Feeney can comment, because him and I looked at each other like, okay.
I disagree slightly, Your Honor. At the conclusion of the hearing, we clarified with the court that the TRO would apply to the named plaintiffs. The court was not happy with that and the idea of potentially hearing the case again, and unilaterally, without a motion, applied a class order. The district elected, I don't think that is proper. I don't think that's enforceable. The district chose to abide by the order rather than appeal it. So
Accurately stated, and I only point that out to Your Honor for the mere purpose of saying there was a third class. Again, procedurally, it had issues. We know that. But I think what's important, for what I want the court to take away from that, is that at least with Judge Schieffer, he was of the opinion that according to his analysis, if I'm going to apply this due process requirement to the named plaintiffs, I'm going to apply it to all similarly situated children. That was his, again, his unilateral analysis at the end of the case. And the school district, again, it doesn't matter, they didn't object. But I think what's important is when the court actually reads the other certification orders in doing the analysis, I'm asking you really to look at it in that vacuum, Judge. Assuming you would grant any relief, does it make sense that we're going to apply this to the similarly situated educators? We have educators who say, yes, I want my rights protected. And there's going to be, of course, educators that say, I don't want my rights protected. They're not harmed. Now, those educators may also want to say, not only do I want to wear a mask and be vaccinated and tested, I want my fellow educators also be forced into that same compliance. That's not a sufficient basis. We've argued that ad nauseum. And again, Judge, I have nothing else to say other than I'd ask the court to certify the class and base its analysis on the propriety that was outlined in those other orders and, again, similar types of cases. Thank you. That's all I have.
Your Honor, one other procedural matter. I think we may already be on record on this in the O2 case with regard to, I suppose this applies to the Carlisle cases, but certainly with the Hillsborough case, the state was not a party in either of those cases at the time that those classes were certified. I think that is relevant, and I think it, I suppose there is a slight open question as to whether the class still exists in the 05 case. The TRO,
I wondered that from what everyone was saying.
Well, the TRO was vacated. The class was certified at a time the state was not a party. So I think that's a bit of an open question. I would contest whether that class is still in existence once the TRO was vacated and the matter was transferred here.
And again, if we can get into that if we have to, Judge. Again, under some hypothetical, the court might grant relief and might certify the class. There was nothing ever filed in the 05 case in Macoupin or in Montgomery County trying to say that that certification was void or improper. So the order is still in effect, right? Okay. If Mr. Feeney seems to think that that order should be dissolved or somehow or another vacated because of some jurisdictional question, or if the state, I guess, if Mr. Verticchio might, they could, if they want to file that, I guess we can deal with that. To me, I think we've got bigger fish to fry in this case. Hypothetically, should the court decide that it thinks class certification is appropriate, and we got to go down that rabbit hole, we would just file something asking the court to apply it to Montgomery County or the Hillsborough School District. But hopefully, again, we don't have to go down that path.
Your Honor, I think the issue is that the decision in Lurkins, which voided the TRO, voided it because the state was not present. I think that same logic would apply to the class. I'm certain the state would raise that. My point in raising it is simply to the extent that there is any persuasive value to these classes that were entered, the state was not at the table when that happened.
Okay.
Those cases had, unique situations. The district in Hillsborough did not take a position on the class, and then the class was never noticed on. So I think those were very preliminary. I think they are of limited value to this court at all in terms of persuasive authority.
Okay.
Thank you.
All right. Okay.
But I want, again, just so, and Mr. Fee and I have usually, again, even though our clients disagree, have always primarily been on the same page, at least what our disputes are. If the court would grant relief, we may have to address that issue. If the court would grant injunctive relief, and then the Hillsborough School District wants to try to actively apply that only to the named plaintiffs, we may find ourselves back in front of you arguing about that issue. So, again, I think we're getting ahead of ourselves here, and Mr. Feeney and I can discuss that, I think, if we need to on the road.
Anyone else want to argue on the class certification? I have this Chicago Public Schools response. I have the state's response that I've read. So please, Brianna is helping me here get everything organized. So if I have not read yours, I will. But go ahead, counsel.
Thank you, Your Honor. Randall Slade on behalf of defendant Roanoke Benson. If I understood the comments that kind of opened this just procedurally, I know I made some arguments in the Austin case.
Yes.
On behalf of Roanoke Benson and a number of other school districts. In this case, I'm only representing Roanoke Benson.
Okay.
So, to save the court a little bit of time, I can simply stipulate that I'll incorporate those arguments into this case.
Okay. Wonderful.
And state my objections. I have objections to the motion. One fundamental issue is we have two different statutes here. Of course, that the court is considering today. We spent this morning and the first part of this afternoon talking about TROs under Section 511-101, which have a very specific set of standards. Everyone knows the case law. It says it's an extraordinary form of relief. It's an extraordinary statutory measure that allows the court to proceed with or without notice following that very tight structure. Class certification is a different animal. It's in 735 ILCS 5/2-801. And the reason I bring that up is because it doesn't have that same a vehicle that allows the court to act with based on notice. My client has not responded to this lawsuit. They're not on the clock to respond to this lawsuit at this time. And that just points out these are two fundamentally different statutes. It's premature to consider class certification at this time from a procedural perspective. Mr. DeBoer said it's not complicated. Class certification is always a complicated issue. There's a lot that's going on. There's, in a traditional class certification case, there'll be discovery. There'll be, discovery of the class representatives. There'll be just potentially discovery of class members. Find out, is the class representative truly capable of representing a class of several other individuals? I think in this case, we've talked on the record about the issues with the Chicago Public Schools, which of course are probably the most public issues, but of course, there is not going to be a possible way for a single individual to represent an entire class of teachers on these issues. And the idea that, one class member is just saying, well, I don't want to wear a mask. I don't want to do the vaccine or testing regimen, that does impact the other individuals in that school, and those in particularly with respect to the staff members. Those staff members have rights as well, and their rights and viewpoints cannot be accurately represented in a class or in a class situation. In a case like this, that destroys the issue of commonality. It also destroys the issue of adequate representation. There's case law, there's reams of case law saying a class representative cannot seek relief antagonistic to non-represented members of the class. And I think that is pretty much sums up exactly why class certification is not appropriate in this particular case. So incorporating my comments from the 5002 case as well, and with that, I will I'll rest unless Your Honor has questions.
No, I think that's sufficient, thank you.
Judge, we've covered this in detail, and I only have one thing to respond. It's this issue, this suggestion that there would be relief potentially granted that's antagonistic. It's almost like going down that path of the irreparable issue being about masks and testing. It's not. There's no relief being requested that's antagonistic. The relief being requested is, are these educators entitled to due process? That's not antagonistic, because those who say, you know what, I'm not going to seek pursuit of my due process, I'm fine with what's going on. There's no harm to them. The proposition of antagonistic is that, well, there are people that regardless of how it implicates them personally, they want to try to take what they desire and supplant and put that onto other people. So me say I'm an educator who I believe in the mask requirements, I believe in the vaccination and testing, and this court might grant some relief that my clients are asking. Does it affect them, their due process rights? No, not at all. But what they're trying to suggest to you is, well, yeah, but those individuals, they also want these other peers of theirs to be forced to do these things too. That's a completely separate, it's a political conversation really, but it's not directly antagonistic to them. It's just something that they have a fundamental disbelief with. But again, that's not, when you're coming to an analysis, would any ruling be antagonistic? No, it's not antagonistic to them. It doesn't affect them at all. Other than there may be other members within their community or within their school that choose to seek the protection of the court. They don't like that. But again, that's not antagonistic to them in the sense of this analysis. That's all I have.
Okay, thank you. Sure.
William Picorni again, Your Honor, on behalf of the Chicago Board of Education and our other school district clients. It's very interesting to hear the remarks Mr. DeVore just made, given the context that the Chicago Board is coming from, when we just had the teachers of the Chicago Public Schools walk out because they're concerned that the Chicago Board is not requiring enough testing, is not doing enough to protect them from COVID-19. So for Mr. DeVore to stand up and say that he and his representative class members are adequately representing the interests of every single teacher in the Chicago Public Schools, Your Honor, it simply defies imagination. And for Mr. DeVore to say, well, a ruling in this case wouldn't harm anyone, Your Honor, we have tens of thousands of educators in the state who vehemently disagree with that standpoint. Now, I know, we're not arguing the merits of plaintiff's position here. That's the hours and hours of argument we just had. So, Your Honor needs to set that aside. The fact is, there is a fundamental disagreement on the merits of the claims that are being made here, and Mr. DeVore can't represent people on both sides of it. His class representatives are not appropriate representatives of people on both sides of the merits of this case. And Mr. DeVore is asking you, he's saying, well, Your Honor, you don't need to consider that there might be another side to the merits of this legal dispute. Well, Your Honor does, and it's fundamental to the requirements for class certification that the plaintiffs adequately represent the interests of all the class members. These plaintiffs cannot do that. And aside from that, Your Honor, Mr. Verticchio very articulately argued all the other points related to class certification in this case. In the Austin case, we agree with all those arguments and adopt them wholeheartedly. I'll leave it at that, Your Honor.
Okay.
Thank you.
Thank you.
Judge, I'm not insensitive, and I've said it before, to the political, what I can only imagine is nightmare that exists within the Chicago public school system. I understand what my colleague says, and you have the teachers union fighting with the board about what they think are appropriate policies. Is this masking policy enough? Is this, is this vaccine mandate enough? Is this, Judge, and I would ask you, that whole debate that we can appreciate that's going on with them, what does it have to do with the issues in front of you today? Nothing. The issues in front of you today have to do with the law, your interpretation of the law, what it means for people to be subjected to certain things. That's the issue in front of the court. Their political quagmire of the, again, got to be extensive. While I might be sympathetic to it, doesn't control the conversation that's what's going on in this courtroom. It just doesn't control, Judge, the fact that they had a bunch of teachers walk out because they didn't think that there was enough protective measures. I understand where they're dealing with, but to suggest that somehow or another should be a factor for you determining whether or not, again, a legal analysis should be altered because of their political realities, again, it's just not appropriate, Judge, and it's not for this case. Should this court grant the relief my clients are asking, and it just chooses to certify the class, the political realities of how that might go on in the Chicago public school system, that's not a part of the analysis. Not a part of the analysis whatsoever. If that was a part of the analysis, we would never have a class certification on a declaratory judgment action like this, because you're always going to have people that don't like the outcome, the practical outcome. But again, this is not about masks. This is not about vaccines. This is, again, about the law and what the law requires, and that's what we should focus on.
Mr. Verticchio.
May I, Your Honor?
Yes.
A couple of preliminary matters on this motion, and they're similar to the preliminary problems with the Austin motion.
Okay.
First, there are absent parties over which the court does not have personal jurisdiction. I don't know whether Mr. DeVore knows whether all the defendants have appeared.
I don't know.
Doesn't even know.
Doesn't matter.
By my count, there's at least 3 district defendants that have not appeared, have not been served, and or their time to appear has not lapsed. Edwardsville, Highland, and Springfield. Plain and simple, the court doesn't have jurisdiction over those parties, and any order entered without the court having personal jurisdiction over those parties is a nullity. It's void. The prospect, the whole notion of a class certification order with absent parties, significant parties, I might add, it just doesn't make any sense. That's preliminary issue number 1. Preliminary issue number 2, again in broad brush, is the same as in Austin, but the details of it are quite different. And that is, the movement is suggesting that the court certify a class with 89 class representatives and thousands. Again, my guess is Mr. DeVore, he's seeking to be class counsel, doesn't even know how many members are in this class. Do you have any idea, Mr. DeVore?
Yeah, it's in the pleading.
I don't see it. I don't see the number of teachers that encompass the entire class. There are 2 people in the caption, Samantha Hellrung and Zachary Bonebreak. We literally do not know who these folks are. There's no allegation about them. They're listed as plaintiffs. They are also listed in the caption of the class certification motion. I don't even know who they are. The other 89 plaintiffs we're proposing to go forward, having them be representatives of this class of thousands and thousands of educators. I don't know what they think about the issues here. Do they think COVID is a hoax? Do they think no mitigation efforts whatsoever are appropriate? Do they think that people with positive COVID tests should be allowed to teach without masks? What do they think? I don't know. The law on this point, Your Honor, is plain, that the court has an obligation to determine and uncover these facts. But without discovery, it's impossible to know. What do we know? We know that, this is from the complaint, the educators teach at one of the districts. That's about it. We don't know which labor unions any of these educators belong to. We don't know the status of bargaining of the unions to which several or many or perhaps most of these educators belong to. As a result, we don't know. And the notion that this is a cavalier, routine issue, it's hard to comprehend. But because we don't know the labor union issue, we don't know who's a member of a labor union, we don't know which of those labor unions are in bargaining over the terms and conditions of employment. As a result of all of that, we don't know whether this court has subject matter jurisdiction over the claims. Less than 2 weeks ago, the 4th District issued its opinion in Glass versus Pritzker, 2022 Illinois Appellate 4th, 210740, reversed a TRO. It was a group of plaintiffs, state employees, on the vaccine issue. The trial court, circuit court in Adams County, granted TRO. There was an affirmative defense and a motion to dismiss based on lack of subject matter jurisdiction because the state was in bargaining in an interest terms and conditions arbitration at the time. The 4th District reversed and said, time out. That's the exclusive jurisdiction of the labor board. Circuit courts don't have jurisdiction over this claim, and that's the exact type of claim that the plaintiffs assert here. Terms and conditions of employment. Are any or all of these 89 representatives subject to a collective bargaining agreement with an arbitration clause? I don't know. That should all be part of discovery. If they are, frankly, the state parties would consider a motion to compel third-party arbitration as a party in interest in that arbitration clause relating to terms and conditions. We don't know any of that, which is a very, very long-winded way of saying this is premature at best. The state parties, the districts, should have an opportunity to discover the 89 purported class representatives and find out about them and find out, among other important issues, whether this court has subject matter jurisdiction over these claims. There's no jurisdiction over parties, that's for certain. There's no discovery. This is premature at best. On the merits, the court wants to proceed on the merits. This is the Illinois Supreme Court in Avery. It's 216 Illinois 2nd 100 at 126. Quote, a trial court's discretion in deciding whether to certify a class action is not unlimited and is bounded by and must be exercised within the framework of the civil procedure rule governing class action, period, close quote. The Illinois Supreme Court went on to say in the Weiss case
also cited in our response, Your Honor, that those seeking to maintain a class action must clear two hurdles. Must clear two hurdles. Plead facts satisfying the statutory requirements and present evidence sufficient to prove the statutory requirements. None of that has happened here. There are no facts pleaded. It's a page and a half motion. And there is no evidence in the record carrying the burden, satisfying the burden of numerosity, commonality, adequate representation, and appropriateness of class actions. We cited you the Lee case before, Your Honor, but the quote is so striking and it applies so dearly to a case like this. Here's what the Lee court said, quote, "In a class action, the trial court is the guardian of the interests of the absent class members." The guardian. It's incumbent upon the trial court to look at the record so it can be the guardian, so it can fulfill its role as guardian of absent thousands and thousands of class members. How can this court possibly be the guardian and fulfill its obligation of being the guardian without a record? There's nothing to look at. What do we know just gleaning from pleadings? Well, on commonality and predominance, we know, and we heard literally hours about it this morning, that school districts may well chart their own course. If the governor's and the state party's mitigation efforts are upheld by this court, the school districts may impose, we heard this morning, may impose more strict requirements. And if the state party's mitigation efforts are struck down by this court, but the school districts are allowed to pursue their mitigation on their local authority, they will be across the board different on what they may do. You may have 21 different lawsuits based on what each school district does, and that is not the stuff of class actions. More importantly, there is a claim in this complaint. 24 defendants, 86 named plaintiffs, and thousands of class members. And there is a claim in this complaint under the Healthcare Right of Conscience Act that is the antithesis of class. It cannot be a class because the Healthcare Right of Conscience Act claim would require a mini trial on liability for every one of those thousands and thousands of class members, because we know from the straight wording of the act that it has to be, assuming the act even applies, it has to be an objection of conscience that is factually driven. Every class member must prove it. But more, the Healthcare Right of Conscience Act allows for the recovery of pain and suffering damages. There would have to be thousands and thousands of trials for every class member on pain and suffering. So we have to have 2 trials for every class member. That is the antithesis of a class action. Adequate and fair representation, and it still is hard to understand. The record that does exist are the affidavits and declarations submitted on behalf of the school districts and the state parties in opposition to the motion for class certification. We know from the state parties' submissions that
the declaration of the teachers union representing 103,000 teachers, educators, is opposed to the relief this class seeks. Those folks believe that the executive orders and the mitigations are absolutely valid. It's not a matter, as Mr. DeVore likes to say, well, they don't want to exercise their rights. That's absolutely wrong. They desperately want to exercise their rights and stand up and be heard on, we believe that we have the right to work in a school where legally enforceable mitigations for COVID-19 are taking place. And the notion that there is a class represented by class counsel that is actively seeking to strip us of those rights is the definition of antagonistic relief sought by the class. How could it be anything else? Mr. Montgomery, the president of the Illinois Federation of Teachers, in his sworn testimony, said that he represents and speaks on behalf of 103,000 members, that, quote, teachers, other school personnel, and students' main protection against the coronavirus in an in-person instruction setting is the implementation and enforcement of the policies of Governor Pritzker's executive orders, close quote. His declaration is attached to our response, Your Honor. So the notion that it's just a matter of some people don't want to don't want to protect their rights, so it doesn't hurt them if we go protect ours. That's just, it's naive, because hundreds of thousands want to desperately protect their rights, and they don't want to be members of a class that is seeking to subvert those rights. In a class action, the trial court is the guardian of the interests of the absent class members. The only record in this case, Your Honor, is you are hearing from those absent class members, and they are saying, no, we view our rights differently. Here's what the court said in the client follow-up case, Your Honor. 105 Illinois Appellate 3rd, 619, 625, quote, critical to a finding of fair and adequate representation is a determination that the representative party is not seeking relief which is potentially antagonistic to the members of the class. Or in that situation, due process prohibits a judgment from being binding on class members, and that's what we have here. And I find it very interesting. Beyond that, it's upsetting to have this characterized as a political issue by class counsel, would-be class counsel. It's not a political issue at all. It's a healthcare issue. It's a personal health issue. It's thousands and thousands of educators who want to work in a setting that is safe, provided with COVID-19 mitigation. It's not political. It's health. These class representatives are antagonistic on this record to thousands and thousands of would-be class members. The adequate and fair representation prong cannot be satisfied. And with regard to experience of counsel, it could well be that Mr. DeVore is well versed in class actions. It could well be that he has taken many class actions through discovery, motion practice, settlement, and or trial and final judgment through appeal. That could well be. I don't know. It's not my burden to present that to the court. It's his. We don't know. And in addition, based on the record here, it's just could not be more clear that Mr. DeVore is adverse to many of his class members. And the Lee Court, I'm reading, it's at page 16 of our brief, Your Honor. Quote, representation of such a broad class by plaintiff's counsel would violate Illinois rules of professional conduct because his representation of one client would be adverse to another client, close quote. That is the situation here, and there is simply no way to deny it. And where does that leave us? It leaves Mr. DeVore hanging on the thin thread of other orders. Well, I haven't seen other orders. I asked Mr. Feeney before I came up, was there an opinion in Montgomery County? It's not part of this record. The answer is no. It was just a one-liner. And then we come to find out that a judge apparently in Clinton County did it on his own accord with no record whatsoever. I question the propriety of that. But that does leave us with Judge Trumper. She issued an opinion. May I approach her?
Yes. Thank you.
She did indeed certify a class. And it did indeed involve COVID-19 issues. And that's about where the similarity ends. The opinion was on September 21, 2021.
But her class was just North Mac, right?
It's far more significant than that, Your Honor.
Okay.
Let's look at, rather than just wave the opinion around and say, she certified class. It was a school district. It wasn't. It wasn't. The line under introduction, Judge Trumper wrote, quote, the issue pending before the court is whether or not the students who have been unlawfully quarantined or excluded from school due to being close contact cases can be certified as a class.
Mm-hmm.
So nothing to do with masks. Nothing to do with testing. And more significantly, the class was only those students who have been excluded as a result of being determined a close contact. That is a subgroup of a subgroup of a subgroup. Here, Mr. DeVore waved his opinion around as if to say, well, Judge Trumper looked at a class that involved a school, she certified it, so hey, what's the big deal? Well, this was an extremely narrow class of folks. Only students who had been excluded. And why is that so important other than the size of it? Because Judge Trumper, now I'm reading from page 5 of her order, Your Honor, she recognized the law. She wrote, quote, the test applied to determine adequacy of representation is whether the interests of those who are not parties are the same as those who are not joined, and whether the litigating parties fairly represent those not joined, period, close quote. And then she finished the paragraph, quote, the representative cannot seek relief antagonistic to the interests of other potential class members, period, close quote. She got the law exactly right. Exactly right. And then she determined, given that the class is limited to those small group of students that had been excluded, had been, past tense, is it antagonistic to those that don't want to pursue this particular class relief? And she determined no. This is, the case before you is completely different. Mr. DeVore is seeking a TRO that if the court were to order it, looking forward, their teachers wouldn't be wearing masks. There'd be no testing. It is a going forward relief being sought, and we know from this record that, 100,000 or so educators are antagonistic to that. Judge Trumper's order is completely different. The only other thing I want to say about Judge Trumper's order,
and I mention it only because it's hard to miss. At page 6, above the heading appropriateness, Judge Trumper wrote, regarding legal representation, quote, defendants have not presented any evidence to suggest Attorney DeVore is not qualified, experienced, and able to handle this case if the class is certified, period, close quote. Well, on that one, she didn't quite get it right.
'Cause you said
The
it's not-
defendants, the defendants have not presented evidence. It's this side of the room, Your Honor, it's their burden to present nothing. The only record that is presented is from the defendants. But we have no obligation to prove to anybody anything about Mr. DeVore's qualifications and experience. That's Mr. DeVore's job. As is his job, if he wants to be class counsel, to plead and prove numerosity, commonality, predominance, adequate representation, and appropriate class relief. And that burden was not carried. Thank you, Judge.
Thank you.
Judge, the order that was issued by Judge Trumper, correct, it was for one school district. We've asked you to consider certifying each of these school districts. So the analysis is the same for each school district as it was that was accomplished there. You also do have the order from Judge Grunke in the Mass case. It's 500,005, which has been again incorporated. His order is in the record. And, you know, they keep coming back to, Your Honor, this antagonism. That my clients are somehow or another antagonistic. And do what Mr. Berticchio does, I'll write it down. He says that these people who find my client's position antagonistic to they view their rights differently. It's important. They, those who would arguably disagree with what's being asked here, view their rights differently. What are we talking about? Do they view their individual rights to object to being treated this way differently? Or is really what they're trying to say to you is they view those who would disagree with them's rights differently? So really what they're saying, the alleged antagonism is that those individuals realize that their life is not impacted at all by a ruling from this court. But those who would disagree with them, they view those who are antagonistic differently. So maybe break it down in English. Those who may say, we want to wear masks, we want to be vaccinated, we want to be tested, etc. Their rights are not impacted. But what is impacted is those other people on the other side of the conversation, they view their rights differently. They want the court to say, you don't have the right to these due process protections. You should be subjected to masking. You should be subjected to testing or vaccination. So the rights they view differently are not theirs. They view the other people's rights differently. That's really what the alleged antagonism is. They don't care. I mean, Illinois, it's an opt-out state, people, and I believe Mr. Slade maybe said, I'm sorry, last time we were, well, they have the right to opt out. Of course they do. Let's say you certify the class for all or part of these school districts. And an educator says, well, I don't like that idea, I'm going to opt out. They opt out. How does their life change? Doesn't change at all. What if they say, I'm not going to go through the process of opting out, I'm just going to keep wearing my mask or vaccinating or testing? How does their life change? Theirs, it doesn't. It doesn't change at all. But again, what they want you to do is to say, we're okay, we can do our thing, but these other people over here who may choose to fall under the umbrella of the court, we want their behavior to be controlled. You're not doing anything to us. You're giving them something we don't want you to give them. And they try to suggest that that makes me antagonistic to these people. Not in this case, it doesn't.
In this case, it doesn't, because nothing the court would be doing would be harming those individuals, not harming them. Are we going to really stand here and say, well, granting due process under the law to these other parties who choose to exercise it, that's harming us? It's not harming them. Not in the eyes of the law, it's not. Not in the eyes of the law, it's not. I'm not antagonistic to those individuals, Judge. None whatsoever. Whether or not an educator can be required to wear a mask, whether or not an educator can be required to be subjected to vaccination or testing, that is a commonality that predominates. It's the whole thing we're talking about. That's all we're talking about. These continue going over and over about discovery and getting into these analysis of I wrote it down, collective bargaining agreements, and these aren't state employees like the case Mr. Berticchio cited. That is complete red herrings. Now, if this court does not want to certify conditionally, of course, you can always change it anytime you want. Certify the class, so be it. But the fact of the matter is, no one is harmed if you do. Everything you've just heard, I can sum it up into a real simple argument. All of it that you heard. The court's going to grant this injunction. We want to mitigate how many people actually are protected by it. So if we don't get class certification and she grants the injunction, at least the named plaintiffs are the only ones that are going to benefit. And it's like they're reducing the potential exposure of a court order. That's all they care about, Judge. But they can't say that to you out loud. They can't say that to you out loud, so they go into these conversations about jurisdiction. Oh my goodness, jurisdiction. Whether or not you have jurisdiction over a defendant has nothing to do with the propriety of a conditional class certification. None. Class certification deals with plaintiffs who might fall under the umbrella of the court's order. Let's say you don't certify the class, but you granted the injunction. Do we still have a jurisdictional issue like they're talking about? Are the defendants not obligated to follow your order? Of course not. Of course you can do that. So what does jurisdiction have to do with class certification? It doesn't have anything to do with it whatsoever. In conflating those two issues, I just got lost in it, ma'am, to be honest with you. I just got lost in it. If you don't grant the certification, what happens? What's going to happen practically? You're going to have some, and I kind of know, at least initially, on the parent case, we'll talk about that tomorrow, that's thousands. But you're going to have some huge amount of people that want to join this case. Court granted an injunction, hypothetically. We need that protection. They're going to start filing and flooding the system with requests for joinder. I suspect you'll let them in. That's the alternative to not certifying the class. So really, again, it's just a delay tactic on the part of the defendants to try to mitigate any potential injunctive request, where it might take them some amount of time to petition the court to get added, etc. And let's say that they do that, Judge. Let's say that you say, no, I need them to join. All of these allegedly antagonistic other persons, there's nothing they can do about it. They can't come in here and argue to you, well, don't let those people join, Judge, because I don't want you to protect them. You can't do that. This is a procedural delay tactic that we're being argued here today. No more, no less. Their disagreements with what my clients are asking, again, these other educators that disagree, they can't use that as a mechanism to say you shouldn't protect those other people, Judge. It's completely improper. Thank you.
Your Honor, may I?
Yeah.
He's got his notes.
It can't be that Mr. DeVore is purposefully missing the point. This is an injunction class.
He's seeking an injunction, not only a temporary injunction, but a permanent injunction. It's an injunction class. Opting out does nothing. Either the injunction issue or it doesn't. So to suggest, well, just opt out, it's a meaningless gesture. He's seeking an injunction that says you cannot have COVID-19 mitigations in schools. And if that injunction issues and it goes to final judgment, and the injunction more precisely is the governor's executive orders are invalid and you can't have masking and you can't have testing, it's res judicata on every class member, every one of them. And they are precluded from filing an action to protect themselves. That is elementary class action fact. So to suggest that doesn't hurt them at all. It hurts them. It's an injunction class action. They're res judicata from arguing otherwise if they're members of this class. And the point that we are somehow trying to restrict the plaintiffs from pursuing what they see as their rights, I have no reason in the world to question the honesty and the veracity and the absolute belief that these plaintiffs hold concerning what they believe the law to be. Just don't force it on 100,000 other people. They can pursue their rights all day long, and that's why we're here. I think they're doing it. But to force it on 100,000 other people that don't want, that view their right as being able to work in a school district with COVID-19 mitigations. And this notion that, we're not antagonistic, therefore, we're just trying to pursue our rights. I wonder what they would say to a lawsuit filed on behalf of a different group of people, seeking to find the executive orders valid and legally enforceable, and seeking to find that as a class action for every educator in the state of Illinois. And I am pretty sure at that point we would hear many, many of the plaintiffs, if not all, saying, no thank you, that's antagonistic to me, I don't want to be in that class. It's the same thing. Pursue your rights, just not as a class. Don't force it upon those that are antagonistic to this relief. We heard it on January 5th, and we heard it again today. Well, just it's a conditional certification. There is no such animal in Illinois law. I defy Mr. DeVore to find it. As far as discovery and jurisdiction goes, Your Honor, it's self-evident. I need say no more. Thank you.
Judge, it won't take you long to find. You can pull up case law that says a court has the ability to grant class certification, amend it, change it, modify it. It's not like once it happens, it's over. Case law's there. But see, the bigger issue here is, again, changing the topic. I've spent the better part of 2 years of my career going, can we stay on point? COVID mitigation, I wrote it down, Mr. Reticchio. COVID mitigation in schools. People want them. Judge, we're not here talking about COVID mitigation in schools. We're not talking about that. And the other thing was, people would disagree potentially, these other 100,000 people, that they want to be able to work in a school district with COVID mitigations. Judge, that's not what this case is about. Not what this case is about. It's what they want it to be about because it sells well for the governor. It's not about COVID mitigation in schools. It's about the law. about the law and whether or not individuals should have the right to be protected under the law. That's what it's about, and they want to keep talking about COVID mitigations in school. I don't care about COVID mitigation in schools. If we think that masks need to be required on some people, the law has provisions that allow that. Do we think people need to be excluded from school because they're a public health risk? There are provisions in the law that allow that. I'm okay with those mitigations. I'm okay with the mitigations that are in front of you in this record, where this court, through the Sangamon County Health Department, entered in mitigations in a school. I'm okay with that. It's about how do we get there. Do we just have COVID mitigations in school because Governor Pritzker and his executive agencies get to write it and make it what they want to be? Or does it have to follow and comport with the law? That's what this case is about. And again, to suggest people want these COVID mitigations, maybe they do. But that's not what this case is about. Thank you.
All right. I've heard enough. I hope all the school attorneys are satisfied.
Yes, ma'am.
Okay.
Thank you, Judge. Thank you, Judge.
Thank you, everyone. I appreciate everyone's time and efforts on this. So, what I'm gonna have Kaylee do, I'm gonna make the class certification arguments a separate transcript. I mean, she's gonna take them all down, but we did that before. So, make the class certification transcript separate from all the other arguments, even that bled over to this afternoon, okay? I'm going to take everything under advisement. I'm tired, as I'm sure you all are too. We have another day tomorrow. I just need someone to get with Kaylee, because you've all indicated that you want a transcript. I think most of you have. But she just needs to know who's gonna be the lead transcript orderer.
I got it.
Oh, Mr. Verticchio has taken it. So, with that, any other administrative stuff before we end?
I think Mr. DeVore and I both have the same question, Your Honor. What kind of, I'm sorry, what time do you have allotted for tomorrow? Are we?
I put 9:30 to noon.
Mm-hmm.
That's enough.
And I know what is before me tomorrow, so that's why I put 9:30 to noon. But that doesn't mean I will not entertain if we need additional time for the afternoon.
Thank you.
Okay? So with that, we will break for the day,
Thank you, ma'am.
and I'll just see everyone tomorrow. Okay. Thank you, everyone.
Thank you.
Thank you, Judge.